Lord, may I be permitted to mention item number 210. Identical matter, my lord, yesterday one matter has been disposed of, grant of 3% additional increment. But in this case, my lord, difference, he is not getting pension. My lord, this upon upgradation, it was appearing last Thursday, item number 30. State advocate paid for adjournment. So that is why it has been bottom of the list. I mentioned on Monday with notice to the other side, my lord was pleased to allow that the matter will be listed on Thursday at the top. Today is the Thursday. Somehow, my lord, it has not been listed today. Well, kindly, my lord, take up tomorrow, my lord, so that, my lord.
Tomorrow, okay. It should appear.
Tomorrow, my lord, just the only difference, my lord, he is not getting paid. Otherwise, yesterday's matter is the same. Same thing.
Okay.
May I have a lordship's kind leave to mention on Madam Millard. This is with regarding grant of affiliation of a college, your lordship.
A grant of?
Grant of affiliation of a college, your lordship. Now, initially, the consent to affiliation was there. Thereafter, they have found some.
Okay, give it. It will appear in the monthly list.
My lord, yeah, before that,
monthly list 5, only 5th.
My lord, may I permitted to this matter, my lord, extreme urgent matter, my lord. It is your lordship's monthly list item number 131. The person crossing the hurdle of 5 tier of selection process after getting the appointment in the training. At the time of training, he got sustained an injury. That's why the respondent authority terminated him from the service without giving any opportunity of hearing. I have filed that has been admitted and directed to file the affidavit. Still date, no affidavit has been filed. My lord, kindly upgrade this matter. Otherwise, the person will this present date, my lord.
My lord, in my lord, may I permitted to mention? My lord, may I permitted to mention upon notice to the other side? My lord, matter is very short issue. My lord, the petitioners are the retired Sahayika of a Shishu Shiksha Kendra. They are entitled to get the one-time ex gratia. My lord, affidavit has already been completed. Everything is completed. My lord, hearing matter. My lord, kindly consider.
Okay.
Yes, my lord. Upon notice to the other side.
Monthly list, let it appear monthly list, then
Deeply obliged.
it would be updated.
Permitted to mention a hearing matter upon notice to the other side.
Okay, monthly list. A monthly list, then according to urgency, you will update, mention for upgradation, then it would be updated. Okay.
For inclusion in the
motion. Motion. Okay.
My matter is, my lord, urgent matter, my lord. The difficulty is that, my lord, the promotion upgradation list issued published by the Kolkata Municipal Corporation. The petitioners before your lordship are the employees of the Kolkata Municipal Corporation. The junior cadres were given higher position, my lord. That action of the authority challenge in the writ petition, my lord. Now what happened, my lord? Again, they are going to issue another promotional list, my lord. So, my lord, if that list is published, my lord, then the writ petition will be infructuous.
You filed an application.
My lord,
in that circumstances, you should have filed an application seeking an interim order. If you have got any material,
lordship,
they have either issued a notice or anything like that.
Lordship,
you can file an application.
Grateful, my lord. My lord, as the matter is listed, my lord.
No, you file an application. But it would be in anticipation. No, you will not be able to place any document that they are making such attempt.
My lord.
You file application. If you file that they are going to publish a further list,
then I will mention it.
Okay.
lordship upon
tomorrow you have some difficulties. আচ্ছা এটা নেক্সট উইক দিয়ে দেবেন এটা ইয়ে আছে বাট ইউ হ্যাভ টু গিভ নোটিস টুমোরো লিস্টটা করবেন কিন্তু টুমোরো তো ওখানে বেঞ্চ আছে লিস্টটা করে দেবেন এটা টুমোরোই আসার কথা লিস্টটা করে দেবেন তারপর যাবে হ্যাঁ 2 PM it will let it appear under the heading tomorrow. Thereafter, it would be accordingly placed. No.
So I'm
He mentioned a forward, so that you can fix the matter.
No, forwarders, so that they have,
But they were not.
you have completed your argument. Supplementary evidence. They have only raised the issue of to be mentioned. Okay, let it appear under the, at 2 p.m. and it will be written. Don't. It will be written. Whether it was pattered. Okay, কালকেটা ইয়েতে দেবেন এটা রিটার্নেবল ম্যাটারে এটা রেখে দেবেন কিন্তু কালকের পরে এটা যেন আর সরাবেন না রিটার্নেবল ম্যাটারই থাক রিটার্নেবল ম্যাটার আন্ডার দ্য হেডিং রিটার্নেবল ম্যাটার 2 p.m. let it appear with the endorsement 2 p.m. thereafter on Monday it will appear under the heading returnable matter.
May I be permitted, my lord, to mention item number 13 of today's list? My lord, in this matter, I am led by Mr. Dhruva Ghosh. For today and tomorrow, he has got some personal difficulty. It's a partnered matter, my lord.
No, not this week.
Let it appear on Monday, my lord. He will come and argue the matter.
That means not this.
Grateful, man.
Yes,
I'm very grateful.
Yes, next.
May I be permitted to mention?
Upon notice, my lord, I am mentioning this matter, my lord. This is the related to, my lord, claim of the LIC. My lord, would remember that on 16 April matter was had before your lordship, but they took the adjournment. I especially indicate my learned friend to fix the matter because it is pending since 2019. Affidavit already has been extended. There is a point of law involved, my lord. Because fraud has been committed by their staff.
When the matter was directed to appear.
Lordship, it is item number 68. My lord, any day after 13 fixed to tomorrow by 2 p.m. My lord, any day. Any day. Choiceable by lordship. Any day.
Item number?
Item number 68. My lord.
68. Have you given notice?
Lordship, I have given notice. She give the consent to me after 13.
এটা আপডেট
Any day.
এটা আপডেটেড ম্যাটার করে
Any day, my lord.
it will appear under the heading updated matter.
May I be,
Oblige, my lord. Oblige.
may I be permitted to mention a matter before your lordship? This is for inclusion, and the only urgency is that a building has been erected close to highway, and my egress and outgress has been completely compromised. That is my only urgency, your lordship.
You made application before the assistant register. Have you made?
I have made.
What assistant engineer has done?
He has said that property
West Bengal Highway or PWD Highway or National Highway?
PWD. This matter has been running in the list.
Okay, monthly list. Let it appear under the. You have not given notice. Have you given notice?
No, lordship. I
give notice.
Lordship, the only urgency.
Hearing matter must be mentioned upon notice to other side. Okay. How you will be able to locate this matter? That suddenly it is appearing
This
in
matter
this
was running in the list, your lordship, but thereafter the
it is
matter,
running in the list.
it was running in the list. Thereafter, it got.
That means you take adjournment on that date
No,
when the matter was taken up for hearing.
It was.
You take adjournment, either it will be placed at the bottom of the list or it will be go top list, will be included in the next monthly list.
It was dismissed for default. Thereafter, we filed an CAN application. That CAN application, thereafter, that matter has not come in the list.
Okay, monthly list. Monthly list on 5th. Monthly list.
My lord, may I permitted to mention for listed motion, my lord?
Motion.
Listed motion. Yes,
Yeah, motion, you give the slip.
Your lordship, similar motion, your lordship.
Yes, yes.
My lord, I have mentioned.
But without notice. Motion means it is of 2022. That means 3 years ago. That means you have already come to
Your
know
lordship, I shall serve a fresh notice.
that who is appearing for the respondent.
Yes, I shall file affidavit service. I shall serve a fresh notice and I shall
That
come back.
today you will mention.
I shall, so I undertake to serve.
You mention it tomorrow. Give a notice to other side. Okay.
My lord, I am mentioning upon notice 120 of my lord's students. That is the urgency.
So 20?
120 of my lord's list. My lord, the urgency is, my lord, it's a essential matter of relating to essential commodities, LPG distributorship. My lord, pleadings has been completed, my lord. Now there is an injunction for which I could not take any step, my lord. My lord, kindly hear this matter any day, my lord.
Oh, that update. Who is the other side? Your other side?
And other side is, my lord, Shubhankar Das. I have served.
Okay, update করে 120, 120. Okay, one.
On 8B6, my lord, I will intimate.
Huh? No, 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 no. Not every matter date can.
Item number 92 of monthly combined list. When I'm paying for upgradation, my fixed any date, my
What is the urgency?
urgency, another is construction, my lord. Private responsibility, another is construction is going on.
Item number?
92 monthly combined list.
Item number. Where is notice?
I shall inform my lord.
No.
Well, I shall inform my.
Allow the court to follow a procedure uniformly. Okay. You give notice, come tomorrow. Every day mention is taken. Okay.
Lord, I'm praying for upgradation of a matter, my lord. Item number 161. The urgency is that the petitioner is in group 2. The petitioner is assistant teacher in a primary school, lord. There was a dispute regarding his date of birth. Although my date of birth has been correctly recorded by the concerned board, my lord, that DPSC is not extending my service, my lord. I have retired on 31st of January 2025, my lord. If your lordship kindly takes this matter.
Yeah, এটা update করে দিন।
My lord, kindly,
Call the list.
my lord, kindly date maybe.
No, 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 no. Next motion. Item number 2.
Lord, item number 2, my lord, I appear on behalf of the municipality. My lord, yesterday the matter was called on. My lord, your lordship, on the instance of the petitioner, my lord, it has been fixed on 6th of May, my lord, yesterday.
Yes, your lord.
It was directed to be fixed on
6th of May. Yesterday it was called on, my lord. On the instance of the petitioner, it was fixed on 6th of
Not
May.
on yesterday, 29th, which was called on, we paid for time and the matter was fixed on next Tuesday, 6th of May.
ও তাহলে এটা 6th of May তে করে দিবি। হ্যাঁ 6th of May তে দিয়ে। Okay. 6th of May. Next.
My lord, in item number 3, Mr. Sengupta is appearing for the petitioner due to some his health issues. He is not present. Kindly make it not this week.
Okay, not this week. Yeah. Not this week.
Oh, my lord, I am appearing on behalf of the respondent.
My application for restoration, Lordship, I am handing up the affidavit of service, which will show that everybody has been served, all the respondents. Lordship, essentially, this writ petition had already been decided by the Honorable Justice Shobhashachi Bhattacharya. We had thereafter filed an application in the writ petition, praying for the enforcement of the writ order because it is in the nature of payment of certain monies. Now, while the matter was pending, it was on dismissed on default, which is why I am praying for restoration, Lordship. On that day, Lordship, I was engaged in
What was dismissed for default? The application.
The application along with the writ petition. Kindly may allow my senior to take over the submissions, Lordship.
My lord, this was really, my lord, an application for enforcement of an order passed by the writ court. My lord, the parent order passed by the writ court was disbursal of, my lord, money, which is, my lord, due and payable under a particular incentive scheme floated by the state. Now, my lord, this order, they were not complying.
After disposal of the writ petition.
Yes. So, my lord, there is a coordinate bench decision of Honorable Justice.
Maybe you go file contempt application.
My lord, contempt, my lord, it really is for, my lord, punishment. My lord, sometimes courts, no, sometimes courts generally, my lord, ensure compliance of the order. I don't.
I have not seen.
No, I
have
don't.
You seen any judgment or order that in a disposed of matter the court has done?
Yes.
Okay, show the judgment.
My lord.
At this point, my lord, Advocate General wanted
my lord,
to
this is exactly, my lord, the point which has been decided by the, my lord, coordinate bench of Justice Shobhashachi Bhattacharya.
My point was not raised that whether execution application is maintainable or not. That point possibly was not raised.
Well, today we are on the restoration. Lordship is not hearing. Let it be restored. Lordship hears it and takes whatever decision Lordship feels, my lord. I would, my lord, persuade your Lordship to hold in favor of the petitioner because of this judgment which I have handed up today, my lord.
But this point was not raised. If I'm not
my lord, kindly comes to internal page 11, Lordship. Devona. This now, okay.
Where is the determination?
Yes, my lord, kindly comes to page 10 of the, my lord,
that a court The
My lord, an argument was raised that the court has become functus officio. This is exactly what was considered by the coordinate bench. Kindly comes to page 10. In the present case, there is an, my lord, I am reading from the, my lord, middle of the page, that paragraph. There is an ingredient of final adjudication of matters in dispute and controversy between the parties by writ court, the order which is sought to be implemented now. However, the said order is not being termed as a decree for the only reason that the same was not passed in connection with a civil suit. There is no reason why section 36, that is of CPC, does not apply, attracting the provisions of execution of a decree in respect of a final order passed by the writ court. Read in such context, Order 21, Rule 11 is squarely applicable to the present case as well. That apart, the functus officio argument is not applicable to the present case at all. It is not the merit of the writ court's final order which is sought to be reopened here in any manner whatsoever. Rather, the petitioner clearly rely on such order and seek an implementation of the same by way of the present application. It has been contended by the respondents that there are several judgments which indicate that order of writ court can also be implemented by a further writ petition.
Yes.
There is no, yes, that is there, my lord. I'm not quarreling, my lord, on that proposition. There is no requirement of going into the question of veracity of such proposition at the present juncture. My lord, the other coordinate bench was
There is no quarrel between the.
I'm sorry, my lord.
Continue.
Yes, there is no quarrel between the said proposition and the proposition now sought to be advanced by the petitioners. Therefore, my lord, both, my lord, another writ petition to enforce a previous order of writ court and an application to implement or enforce an order passed by the, my lord, writ court is permissible in law. That is exactly what the learned judge, with deepest of respect to my understanding, has recorded here. The mere fact that a further writ petition can be used to attract the attention of the writ court and seek implementation of its previous order does not operate as a bar or is not mutually exclusive with the power of the writ court to implement its order by whatever name called. Implementation, enforcement with special reference to section 36 of the Arbitration Act and execution are interchangeably used in Indian jurisprudence. Hence, there is no quarrel, as reiterated above, between the proposition as sought to be advanced by the respondents and a decree passed by a writ court being executable in an application for execution. Invoking such consideration and principles of law as discussed above, there is no impediment in the writ court invoking its inherent jurisdiction, read in conjunction with Rule 53 of the writ rules of the appellate side rules of this court, as well as Section 36 and Order 21, Rule 11 of the CPC for enforcement of its own decree. Petitioners are thus entitled to implement the order passed by the writ court as per prayer made in the present application. Now, my lord, pausing here for a moment. Today, I am only, my lord, bothering your lordship with my application for, my lord, recalling of the order of dismissal for default. My lord, lordship will kindly permit me, my lord, I will also look upon other judgments similar to this line, my lord, if I, my lord, find, and I will try and assist your lordship, that lordship will hold in our favor, and also, my lord, in same line as the coordinate bench has, my lord, held. So kindly gives us that, my lord, opportunity, restores the matter and fixes it any day lordship, my lord, deems it fit. We will come back with authorities and, my lord, try and convince your lordship that this is permissible in law. If I fail to do so, I know, my lord, the fate of the application. Lordship is going to otherwise then, my lord, reject it. But I'll try and convince your lordship. Kindly restores, my lord, the application. Today, I am only bothering your lordship with the restoration.
What is the number of the application of your restoration application?
My lord, that is Can 3 of 2024.
Can 3?
Yes.
When it was dismissed?
My lord, the order of dismissal is at page 11 of the, my lord, application.
Within the period of limitation?
Yes, my lord. 20th of November 2024, it was dismissed. And, my lord, 2nd of December, within 10 days, my lord, we had filed it. My lord, my lord, the advocate was there. I've given the explanation. He could not reach when the matter was called because the list had collapsed, my lord. My lord, I have a copy of the can. If lordship wants, lordship, I'll give my copy, my lord. Kindly comes to page 11, my lord.
Oh, can has not been tagged.
My lord, kindly comes to page 11. That is the order.
Yes, page 11.
No. Application to dismiss. So, I mean, restoration W. My lord, kindly comes to
petition can be dismissed for.
Yeah, that is exactly my point. The writ petition was already disposed of. It was only Can 2 which was listed for implementation of the writ court's order. Can 2 was dismissed for default. My Can 3 is only for restoration of Can 2.
Yeah. can 3 of 2024. This is an application.
Yes. Sundip Das to.
The petitioner one.
Lordship, I am for the respondent Union of India.
But this matter, my lord, pertains to my lord. The medical decategorization, my lord, of the RPF constable.
Medical
Categorization of the RPF constable, Railway Protection Force constable. So, my lord, what happens here, my lord, this incumbent, my lord, falls sick while he was in service in 2020. And my lord, he was having a problem, my lord, with respect to his hand. Some tendon was transferred or something, and for that reason, he had he could not just open the claw. So, my lord, at that particular time, my lord, he was examined by the railway doctors. So, after examination, the railway doctors opined that he should be given with the light duty, where, my lord, the firearms would not be used, cannot be used by this particular individual. So, my lord, thereafter, after this recommendation of light duty, my lord, he was in RPF. He has been in RPF. So, since in RPF, my lord, basically there cannot be any light duty where no firearms or lifting of firearms or bending down is not included. There is no such job in RPF also. He was placed in sick list. So I am just coming to your lordship about this provision of this medical decategorization, what is sick list and everything. So he was placed in sick list. So he was in sick list from March 2019 to October 2019. 5th of March 2019 to 31st of October 2019. So which is, my lord, more than 7 months. So after that, my lord, he was not issued with the certificate of decategorization, which compelled the writ petitioner to come before this honorable court. So, my lord, the rule I am just placing your lordship, the rule is, if someone is having this kind of problem, this kind of disability which is accrued, it is not disability, illness. So in that event, he will be recommended for light duty. I have annexed the provision. So after recommendation of light duty, if the department do not find, the entire departments, my lord, they do not find that they do have any job where light duty is involved, then he will be placed in a situation which is called a sick list. So that sick list, he can be there in the sick list highest for 6 months. Within 6 months, the department will be trying, my lord, to find the possibility so that he could be engaged somewhere with the lighter duty. So this period of, my lord, being there in the sick list is maximum is 6 months. So after 6 months, if it is found that this incumbent cannot be placed in lighter duty, so in that event, certificate of decategorization is issued. So this certificate of decategorization is what, my lord, earlier occasion when your lordships are sitting in the division benches, my lordship has passed several judgments on this. Means, my lord, in the railway recruitment, there are medical categories like A1, A2, A3, B1, B2, B3, C1, C2, C3. So if someone like this individuals who are working in railway protection force, they are having the A1 medical category. So if he is decategorized, he could be, my lord, placed in C3, let us say, C3 medical category. If he is in C3, he will be given with the employment in railways, which is commensurate with the C3. So this is called the certificate of decategorization. Since that was not given, even after expiry of 6 months in the sick list, the petitioner has come before this honorable. That is the provision of law. If I just can take your lordship only to the provision once. Page number 23.
Page number 22, prescription.
23.
23 and onwards.
Which says that annexure P2 starts with section F.
Section, yes. Section A.
Yes. So, that is the Indian Railway Medical Manual extract of that Indian IRMM, Indian Railway Medical Manual. So, 559 says the type of medical recommendations. It says the medical recommendation that are issued to the respondent railway employees by the railway doctors comprise the following. 1. Recommendation of light duty or change of occupation. So we are concerned about that only. 1. So 2 says recommendation for transfer postponement and cancellation of transfer. 3 says recommendation of allotment of railway bungalow and etc. So we are concerned about 1 recommendation of light duty change of occupation. But it kindly comes down to 561. Recommendation of light duty. Such recommendations are to be made by a railway doctor in favor of the employee when, in his opinion, the railway employee who had been under treatment for serious illness or injury is fit to resume duty in his original post, but not fit to perform all the duties connected with that post. So he is fit to join the duties, but not fit to perform all the duties. So then the recommendation of light duty will be issued. Then 2, the medical officer of the rank of DMO or above, before making the recommendation, should first ascertain from the competent authority, such as the departmental superior of the employee concerned, whether it will be possible to provide the employee with such duty of light nature in his original post, which will be compatible with the railway working. Whether that will be possible in that particular department, that will be ascertained by the medical doctor. Then 3, on hearing from the competent authority that such a request can be complied with, if it is found that request can be complied with, in that event, the railway doctor will make necessary recommendation in the prescribed form as given in annexure such and such to this chapter, specifying the nature of light work or occupation and the specified period for which it is recommended. Such a recommendation should not exceed a period of 3 months in the first instance, after which the case should be reviewed, and under no circumstances should it exceed for a period of 6 months. So, a recommendation can be given where it will be specified that what kind of duties that individual can perform and what he should avoid. So, this recommendation should not be more than 3 months at the first instance, and in aggregate it should not be more than 6 months. Then, my lord, comes down, my lord, to 4. If the competent authority indicates its inability, that is important, my lord. If the competent authority indicates its inability to provide a temporary light duty or change of occupation, the employee should be kept on sick list till he is fit for duty or is decategorized. The period for waiting should not exceed 6 months. So, my lord, there is a concept of sick list where basically these incumbents are not paid. So it is a situation where, my lord, he can be placed as a waiting person who can be either, my lord, fit to join the duty or is decategorized. So if someone is placed for 6 months or more, then it is evident that he cannot be placed on duty back. So he has to be decategorized, which will be evident from the next part. B, certificate of decategorization of change of occupation. If after expiry for the period of 6 months granted under the certificate of recommendation of the light duty, the employee is considered by the railway doctor medically unfit for the duties of his original post, but not unfit for service to other posts, the competent medical officer will issue the necessary certificate in the prescribed form as given in such and such to this chapter for a suitable permanent alternate appointment either in the same medical category or in a lower medical category, as I was saying, man. So since this individual admittedly was there in the sick list for more than 6 months, there is no other option in the hand of the employer to, my lord, issue a certificate of decategorization in his favor. Means, my lord, he has to be, my lord, decategorized. He would be placed in a lower medical category. He will be placed in a duty where all these problems are not involved. So this is the law. Then, my lord, I'll just take your lordship to the facts of its instant case. My lord, there are the medical prescriptions or of the medical doctors of the railways which have been annexed from 16 onwards. But I'll just request your lordship to see the last page, which is page number 22.
Yes.
Just before the page which your lordship I was placing.
Yes, yes.
So, my lord, in 2019, my lord, it is said, I'll just try to place, my lord, the handwriting may not be, my lord. So the first 4 line I'm skipping. Patient fit to join duty, but he is to be given light duty not involving lifting of heavy firearms. So this is, my lord, the recommendation. that of the railway doctors. Then my lord kindly sees the supplementary affidavit that I have filed, because my lord mistakenly the sick list thing was not appended in the writ petition when it was initially filed. This the Honorable Justice Banerjee, my lord, was pleased to, my lord, grant us liberty so that we can file the supplementary affidavit. So, my lord, the supplementary affidavit your lordship will see, which is, my lord, affirmed on, my lord, 10th of January 2023. Yes, my lord. So, my lord, from page number 4, the sick list documents, my lord, have been annexed. Lordship will see at page number 4, it is medical department interim sick certificate. So, my lord, kindly see, comes, my lord, page number 5. There, your lordship will see that period has been mentioned. 17th March 2019 to 31st March 2019. For that means, my lord, for 15 days. So all these documents after that, my lord, have been annexed. Lordship will see, kindly skip over all these 6 certificate. That was means, my lord, time to time he was being reviewed, whether he could be placed in the sick list or could be taken back to the employment. So, my lord, then, my lord, last I'll take your lordship. Page number 12, your lordship will see once. 12 is the first one. The annexure could have been, my lord, placed properly. I'm taking your lordship's apology for this. My lord, 12 is 1st of March 2019 to 16th of March 2019. 1st March. 1st March 2019 to the 31st October 2019. Yes. So these are all the 6 certificates, my lord, annexed. So now you want them to issue a decategorization certificate in your favor. In this meantime, my lord, the involvement, the involvement in the writ petition, I must apprise to your lordship that since this individual was there in the 6 certificate during this pendency, my lord, I came before this honorable court when this litigation was going. Since lordship, as I have already addressed to your lordship, that being in the 6 certificate disentitles an incumbent to get anything, means no salary is given to them. So this incumbents, my lord, because of their my lord, financial situation, because they're starving, my lord, they are the constables. So, my lord, they had to join the duty right now. They have been working in the RPF only with this kind of situation, medical condition where he cannot open his claw with the firearms. So, my lord, I just now, my lord, my client just has handed up, my lord, to one last document. If I just can apprise to your lordship to this, which is of. So after expiry of that period, you have joined. You are forced to join. I am forced to join. Yes. So, my lord, it is 11th of March 2025, the railway doctor's document. If I can place, my lord. Yes. 11th March 2025. This is a case of Hansen disease. Ulnar claw hand at right upper limb. Man palsy is permanent due to the nature of disease and unlikely to improve in the future. Category of fitness to be at your end by AEMG. He is unlikely to use firearm with present deformity in future. So, my lord, this is the last medical, my lord, examination of 11th of March 2025. I'll just give up, my lord. Okay. Of this incumbent. Now, my lord, before I just take your lordship only. This situation, my lord, has come before this honorable court on the earlier time. My lord, the honorable single bench, my lord, was pleased to, my lord, grant this the benefit of issuance of this this decategorization in this matter, and my lord, that was allowed. And subsequently, my lord, the Union of India preferred the appeal before the honorable division bench. When, my lord, the division bench also was pleased to, my lord, affirm the order of the honorable single bench. My lord, here before the honorable single bench, my lord, in the Ravi Prakash's matter, so, my lord, this entire gamut, my lord, has been examined. If I just request your lordship, it is an exhaustive order. They have already complied with. They have already complied with this. The order. They have, yes. They have filed. And in the interim stage, my lord, they went before the honorable division bench, where the honorable division did not interfere. Said that the certificate of decategorization is, my lord, as per the law, since it is as per the law, the entire decategorization thing, my lord, has to be given to this incumbent. So they have, yes, my lord, they have complied with, where my learned senior, my lord, was there representing the RPF authorities as well. So, my lord, this is my submission before your lordship. Only I pray before your lordship is that now I should be, my lord, issued with this certificate of decategorization. And after that, my lord, whatever, my lord, is my medical category, I should be placed according to that only.
Yes.
Lordship, there was a direction from the Honorable Court to file a report in the form of affidavit, which was filed. It is in the record. Everything is mentioned over there. And as per last report, dated 26th of June, 2023, I have been given to understand that.
Yes, you go ahead. Exception on behalf of the
report in the form of affidavit, Lordship.
Exception, I have taken.
Exception from that side.
Yes. Please go on. What was stated in the report?
Report?
What you have reported to the court?
Point number, serial number 4.
Oh,
of the
yeah, Babu. Don't report that.
Report in the form of affidavit.
Yes.
Point number 4, Lordship.
Point number 4. Yes.
Can I read, Lordship? The petitioner was placed on the sick list on and from 5th of March 2019 to 31st December, 31st October 2019 at KG Hospital, for which time to time interning SIP certificate was issued from the said hospital. ACMS issued a fit certificate number so and so, data so and so, where it was declared that petitioner is fit for same category of job, with a remark: the petitioner should not be asked to handle firearms, and he was discharged from sick list by discharge certificate number so and so, dated 31st of January. Further, it was recommended that petitioner should be entrusted with light duty not involving lifting of firearms. Now, as per report dated 21st of June, I have been given to understand that there's a report in terms of that. And that was the latest report. In reference to Honorable High Court order dated so and so in the matter so and so, Wachintakuan Mandal was and others regarding discharging of lighter duty as per medical recommendation. It is to submit that the petitioner Wachintakuan Mandal Constable so and so was declared medically fit by medical authority CL Chittaranjan for duty in same category without use and handling involving firearms. As per recommendation of medical authority and by his application, so he was allowed to resume duty, and since then he has been discharging his duty accordingly without use and involving to handling a firearm as per certificate so and so. So this is the latest report. He is discharging duty without involving any firearms. He has been entrusted with light duty. He is continuing with his duty. And the latest report, which my friend is showing, I don't have the report with me. I have to get the latest instruction as to what is the latest position.
One force will work without having any ability to lift the firearm.
Violation of
What sort of thing is it? Today you will allow any police personnel to perform who has no capability to lift firearms,
when he is performing,
or to have no capability to run, or physical capability to chase any accused person, any criminal, will you allow?
No, only that
They get salary from your money, from the taxpayer money. Will you allow? Or will you allow any soldier in our border to perform who has no capability to lift any arm? Will you allow?
Also, as per medical report recommendation, he is given light duty. He is performing it. He is discharging duties without any complaint.
It would be better issued a decategorization certificate and assign him a lighter job in any department, any other department.
The matter is come after long time. I have to get the latest position.
No, how much court will owe it?
Give me 15 days, Lordship.
Court has applied their mind. Sufficient judicial hour has been consumed. Now allow the court to take decision. Now again, it is an indecent one thing. So your IG come principal chief secretary also suffering from some indecent. He is one person, one force. He is being allowed who cannot, has no ability to leave the arm. Although he is force. As a force, he is getting salary. So assign any clerical job or anything like that.
No, he has light duty.
You are saying he is getting salary. So why you are
Sir, he is working.
why he is agitating this point?
Lordship, he is working. He's working.
So his contention that he has been placed or being assigned light duty, and you are drawing salary now. So there is no requirement to interfere.
I myself volunteered by saying that I want, my lord, some lower medical category job. If I am just, my lord, after this salary, I could have easily said that yes, I am confident. Lordship, kindly the compilation that I have handed up to your lordship in the month of my lord, March 2025 also, I have been sent, my lord, in the firing range. That is their document. So this is the contention that is right now being forwarded to your lordship is not right. I'm sure, my lord, my learned senior is not having instruction to that effect.
Lordship, that's why
this document that handed up to your lordship, he has been sent for the firing range. In 2024, he has been sent. 2025 also he is sent. So, my lord, he, on the other hand, the railway doctors.
So I am sending them to the authority. They consider that such and such, this ability is permanent.
Yes.
When a doctor has said that permanent, that means deformity is permanent. Okay. So such this permanent deformity has rendered him unable to leave the firearms.
That is correct. That is correct.
This is one of the
that is correct, Lordship.
So you issue the certificate and place him at.
It is for everybody's win. And my lord, this is the second part.
As per medical, Lordship, as per medical recommendation, he has been given light duty. He is performing it, Lordship.
This is not right.
So either recording this thing I am going to dispose of, I am to dispose of the petition. Now choice is your. Mr. Roy, what can be done? He is saying that following the recommendation of the doctor concerned, you have been now being assigned in lighter duty and you are drawing salary.
That is the wrong contention because I have handed up to your lordship, my lord, the situation present. And secondly, if we just do not go into the facts, if we just go into the law only, my lord, the law says that if someone is kept in the sick duty for sick list for 6 months, he has to be given with the certificate of decategorization. So, my lord, admitted position that he has been in the sick list for more than that. Only on that point.
Okay.
Only on that point.
Citing inaction on the part of the concerned respondent to issue decategorization certificate in favor of the petitioner, the present petition has been preferred. Stop. The petitioner joined the railway
protection
force in short Kurodin RPF when
I joined, I tell you, lordship.
Okay. On 1st May 2028.
Yes, I'm sorry, man. I couldn't.
No, 2008. 1st May 2008. When you fell sick or
in 2019.
In 2019, in course of his employment, he fell sick. And
page number 19, man.
Page number 19.
16 onwards. 16 is the first document.
He was placed before the
Sick list. At first sick list, your lordship will see supplementary affidavit.
concern before the medical officer
Yes.
to verify his physical condition. And it was detected that he got one problem. One issue, problem, one inability following that issue. He lost his inability to open his claw properly. So, subsequently, The petitioner 8 weeks from date of receipt of a copy of this order. ঠিক আছে?
That's all, my lord.
Next.
Item number 7, Lordship, my appearance for the respondent bank. Your Lordship, before the petitioner starts, may I appraise your Lordship, by an earlier order dated 21st of March, the coordinate bench was pleased to direct me to file a report in the form of affidavit. May I be permitted to file?
Yes, what's the matter about?
স্যার, পাঞ্জাব অ্যান্ড সিন্ধ ব্যাংক থেকে আমার দুটো লোন ছিল, একটা ক্যাশ ক্রেডিট, একটা হাউস বিল্ডিং। 6 লাখ টাকার ক্যাশ ক্রেডিট ছিল এবং 2 লাখ টাকা হাউস বিল্ডিং লোন ছিল। স্যার, এটা আমি 1/1/2005 থেকে 2021 অবধি আমি ইন্টারেস্টটা দিতে পারিনি বিজনেস ডিফল্টের জন্য, যার ফলে ব্যাংক আমার এগেনস্টে 2008 সালের DRT 3-তে একটা সারফেসি একটা মামলা ফাইল করে, এবং সেখানে যে মামলাটা ফাইল হয় সেখানে তারা যে স্টেটমেন্ট অফ অ্যাকাউন্টসটা ফাইল করেছিলেন সেখানে প্রচন্ড পরিমাণে ফ্রড দেখা যায় স্টেটমেন্ট অফ অ্যাকাউন্টসে। আমি আপনাকে বলবো স্যার, পেজ নাম্বার 26, এটা একটু যদি দেখেন। প্যারা নম্বর 14।
আপনি কোনো অ্যাডভোকেট নেবেন লিগ্যাল এড সার্ভিস থেকে?
না স্যার, আমি দেবো না, তার কারণ কিছু প্রবলেম ক্রিয়েট হচ্ছে বলে আমি নিতে পারছি না, সেটা আমি বলতে পারছি না ইনিশিয়ালি আপনাকে।
কেন আপনি করতে পারবেন? এইগুলো কেন করছেন আপনি পারবেন?
এনারা আমাকে যে জায়গায় ফিনান্সিয়াল জায়গায় নিয়ে গেছেন সেখানে আমার কিছু করার নেই। 24
একটা পয়সা লাগবে না স্টেটে।
তার জন্য না স্যার, এখানে
সে অ্যাডভোকেট একটাও পয়সা নেবে না, আপনার কোনো খরচা হবে না
স্যার, সেটা আমি বুঝতে পারছি, কিন্তু কিছু কিছু ম্যাটার গুলো এমন ভাবে রয়েছে যেটা অ্যাডভোকেটকে বোঝানো খুব টাফ। যেভাবে
না আপনাদের এইগুলো জানি না দেশের আইন সব আপনি বলবেন রাইট, কিন্তু বাট a minimum a basic understanding of law তো is required.
সে তো স্যার আমি নিশ্চয়ই, আমি যা পরপর আপনাকে এভিডেন্স দেওয়ার পর কিছু
এই যে ফ্রড কথাটা বললেন, ফ্রডটা প্রমাণ করতে হয়।
স্যার সেটা আমি
রিট কোর্ট কি তার জায়গা?
না, সেটা তো আমি প্রমাণ করবো স্যার।
প্রমাণ করতে গেলে এভিডেন্স দিতে হয়।
সব দেবো স্যার, আমি সমস্ত রকম এভিডেন্স দেবো।
ফ্রড ইজ টু বি প্লিডেড এন্ড প্রুভড।
আমি দিয়ে দেবো স্যার,
ছোটবেলায় সব ছেলেরা পড়ে। তাহলে এটাই বেসিক আন্ডারস্ট্যান্ডিং অফ ল। আপনি এখন রিট কোর্টকে বলছেন যে ফ্রড হয়েছে, রিট কোর্ট এখন কি করে এভিডেন্স নেবে?
কিছু কিছু
আপনি বই এনেছেন সেই রুলটা, যদি if fraud you find out that in case of fraud auction held by the court order 21 rule 89 or 90, then a person can claim that there was a fraud. And sale was on earlier date he stated that sale was held below the reserve price. Fraud can be stated if sale is held below the reserve price.
একটু যদি বাংলায় বলে আমার ক্ষেত্রে
আর্টিকেল 348 এখনো চেঞ্জ হয়নি দেশে।
Lordship, may I
official language of the High Court is English.
May I appraise your Lordship with some facts, your Lordship?
Yes.
The only thing is, Lordship, what has happened?
যদি বলেন ভালো হয় আমার ক্ষেত্রে।
Lordship, if your Lordship permits, then I can.
And hence I am saying that you can take an advocate from Legal Aid Service Authority. Government has, state has make arrangement. Okay, কি আপনি রুল টুল কিছু এনেছেন?
স্যার
এখানে আপনি কি চেয়েছেন?
আমি চেয়েছি স্যার আমার প্রপার্টিটা যেভাবে বিক্রি হয়েছে আন্ডার
বিক্রি হয়েছে আইন অনুযায়ী, আপনি লোন শোধ করেননি, আইন অনুযায়ী হয়েছে,
প্রপার্টিটা বিক্রি হয়েছে স্যার।
আচ্ছা, আপনি have you filed any report in form of affidavit?
Yes, that is before your Lordship.
Have you served the
Yes,
copy?
কোনো সার্ভিস হয়নি।
Yes, I have served. Yes.
এখন অব্দি
তাহলে আপনি কপিটা দিন, আপনি দেখুন, সেই কপিটা দেখে তারপর যদি মনে হয় আপনি এটা প্রেস করবেন তাহলে করবেন, না হলে করবেন না। কপি have you served copy?
আমাকে এখন সার্ভিস হয়নি স্যার।
Surface Act, have you brought Surface Act?
Yes, it is. Your Lordship, may I be? I have brought Lordship. This is a recovery proceedings. May I appraise your Lordship of the facts, your Lordship?
Okay, short, be brief and still.
Yes. The only thing is, your Lordship, we have filed an original application under the RDDB FI Act. Your Lordship, after that,
we have obtained a recovery certificate and RP was initiated, recovery proceedings. And there we have obtained an order and for sale of the petitioner's mortgage asset. May I take your lordships to the kindly comes to lordship page number 21, your lordship.
Report is not with the record.
If your lordship kindly comes, the only thing is that is a order which is passed by the learned tribunal. Your lordship kindly sees that he is saying that his entire property is not siphoned off. But here it has been clearly mentioned that his entire land along.
Report where file it in the court.
Yes, your lordship.
No, where is the report?
Yes, I have just filed, your lordship.
Just file today?
Yes, today only. Today it was
today. Oh, where the yes.
The report on.
Yes.
Kindly comes to page 21. It's a very short matter, your lordship. Nothing is there. Page 21.
DRT.
Yes.
Debt Recovery Tribunal.
Yes, your lordship. It's a
আপনি
recovery.
জানেন ডেট রিকভারি ট্রাইব্যুনালে গেছিল পাঞ্জাব এন্ড সিন্ধ ব্যাংক দেবাশিস সরকার প্রপাইটার দেবাশিস সরকার কি আপনি কানন সরকার আচ্ছা এদের বিরুদ্ধে গেছিল ফাইনাল অর্ডার হয়েছে 11 এপ্রিল 2014 11 বছর আগে আপনি জানেন না এটা তাহলে তাহলে কি
তারপর বলবো স্যার আমি একটু
Your lordship, there's a provision of appeal also.
আপনি এর অ্যাপিল করেননি?
No, he has not appealed. The time has expired. He has missed the bus.
কোথায় অ্যাপিল করিনি স্যার 2015 তে আমি অ্যাপিল করেছি
Your lordship, he has not challenged the order of the RP, your lordship.
তারপর রিকভারি প্রসিডিংস এদিকে আর
Your lordship, all the points which has been raised in the writ petition has already been dealt. Kindly see. Of February, it will clear
এখন কি করে কি
everything. Every single contention which has been raised here before this court has already been dealt with by the DRT. Kindly sees all this. This valuation point, everything was dealt with already.
CD1 means who is CD?
CD is he. And we have the CHB, where we have the certificate holder bank.
তা আপনার কেন মনে হলো ফ্রড হয়েছে?
Your Honor, 2014 সালের পরে আমি 2015-তে DRAT তে অ্যাপিল করি এবং
আপনি তো অ্যাপিল করেছেন এবং রিকভারি প্রসিডিংসেও তো আপনি অ্যাপ্লিকেশন ফাইল করেছেন।
না স্যার 15 পর থেকে আরো কিছু আছে।
আপনার মেন ব্যাপারটা হচ্ছে যে আপনার কম ভ্যালুয়েশনে আপনার জায়গাটা বেচে দিয়েছে।
হ্যাঁ, কম ভ্যালুয়েশনে জায়গাটা বেচেছে।
আচ্ছা, সেই জিনিসটা তো আপনি এজিটেট করেছিলেন ইয়েতে রিকভারি প্রসিডিংসে।
রিকভারি প্রসেসিং
আপনি এজিটেট করেছিলেন, আপনার সেই পয়েন্টটা করেনি যে আপনি যেটা বলছেন যে আপনার যে নিজস্ব ভ্যালুয়ার সে যা ভ্যালুয়েশন করেছে সেটা অ্যাকসেপ্ট করতে হবে।
না, আমি সেটা বলছি না। ইওর অনার, গভর্নমেন্টের যেটা নিয়ম আছে সেই ভ্যালুয়েশনটা তো অ্যাকসেপ্ট হবে।
গভর্নমেন্টের যে নিয়ম আছে,
গভর্নমেন্টের যে ভ্যালুয়েশন আছে, কিন্তু এনারা যে সিস্টেমটা ভ্যালুয়েশন করেছেন সেটা পুরোটাই রং, কোনো রকমই নিয়ম মানেনি। তার কারণ আমাদের ওখানে সিস্টেম হচ্ছে, কেএমসি নিয়ম আছে যে স্ট্রিট নেম অনুযায়ী ভ্যালুয়েশনটা ডিফার করে, ঠিক আছে? সেখানে ওনারা কি করেছেন, পোস্টাল অ্যাড্রেস দিয়ে ভ্যালুয়েশন করেছেন।
So there's no specific provision as to
rule 9 or anything. Have you got the rule?
No, your lordship. The only RDDBI, if I can show your lordship the provision.
No.
The rule.
Securitization Act and.
Yes, yes. Surface sector. Your Lordship, also one thing which is very interesting to point out, Your Lordship, kindly comes to page 46 of my report. Your Lordship sees there's any rule as to that. First,
Now the provision of auction, provision of
Little
auction
knowledge.
securitization of
to come back on this thing.
there is a rule, most probably rule 9 or anything, securitization
Your Lordship,
enforcement rule.
rule 8(1) is the 13(4). There's rule 9 is the may I? There's a rule for auction.
9 sale shall be confirmed. 9.
Your Lordship,
No.
This is a recovery proceedings, Your Lordship. This is a recovery proceedings. I have filed an OA. I have obtained a certificate of recovery, and then I have filed a.
Okay,
It's not a
recovery
section
of the
34-14.
amount.
Yes.
Recovery of the amount. Thereafter, to recover the amount, the property was put on sale by auction.
By the RP. By auction. Yes.
By auction.
Auction, the RP.
Now, whether the said auction process was conducted legally or not,
Yes,
it
absolutely.
is his grievances.
Absolutely legal.
Okay. Now, what is the procedure? Issue of certificate of sale, such and such, and
May I appraise, Your Lordship?
yes,
Your Lordship.
you just show me the
sale, right? Your Lordship.
Look, the grievances as ventilated from him indicate that
I shall.
fixation of reserve. What is her? Fixation of reserve price, main grievances in all auction sale. And the main allegation comes that my property was more valuable and it has been sold as a lesser value and below the reserve price.
Lordship.
Or reserve price has been diminished at this problem. Okay. Same problem, order 21, rule 89, 90, such and such, and then the question of fraud comes.
Your Lordship, may I?
আপনার সম্পত্তিটা কম দামে বেচে দিয়েছে। হ্যাঁ,
যেটা গভর্নমেন্ট
সবই একই কাণ্ড।
না স্যার, গভর্নমেন্ট যেটা সিস্টেম সেই সিস্টেমটা তো আমরা মানেননি। আর আরেকটা জিনিস ইওর অনার, ইনি যেটা 37টা দিয়েছেন, পেজ নাম্বার কত বললেন জানো? অর্ডার নাম্বার 37 এর পেজ নাম্বার কত বললেন?
You will show the provision. The provision main disputes comes.
Your Lordship.
You are handling the brief much prior. That where is the provision of fixation of reserve price? Whether valuation of the movable secured asset, sale of movable, no, immovable property.
Every order has been annexed, Your Lordship.
Yes. Rule 8. Come rule 8, 7. Every notice, sale notice, notice of sale, what sale notice shall contain? Description of immovable property, then the secured date, then the reserve price of the immovable secured asset, below which the property may not be sold. Most of the problem lies here. And CPC has actually what you have done.
May I appraise
you have
May I appraise, Your Lordship? The total reserve price is 45 lakh.
excluded certain CPC is very good procedural law.
Yes, Your Lordship.
And the bank legislature has excluded or eliminated such a provision and incorporated such and such. The application for satisfactory to sale on deposit, it is 89, rule 89. Very good. Rule 90. The application to set aside sale on the ground of irregularity and fraud. And order 21, rule 90. Whether any such provision is available in this rule.
Your Lordship, may I appraise, Your Lordship? The point of law Your Lordship is saying, Your Lordship, the only thing is whenever there's a recovery proceedings ongoing, whatever the recovery proceedings is conducted by the recovery officer, and he has to file an appeal. And so far as the reserved price was 45 lakhs 54,000, and the total sale amount which has been done is 47 lakhs 43,000 something. The only problem, difficulty is, your lordship, this is a 2014 recovery proceedings, your lordship. Then your lordship has to call for the records, because the records are very old, or I have to apply for the certified copy. I do not have all the orders also from the website. This is, I'm only submitting on instructions that the value has been. Your lordship kindly comes to page 29. There's the reserve price is also mentioned. 27.
প্রপার্টিটা কত টাকায় ভ্যালুয়েশন করেছিল?
Your lordship, that is at page.
কত টাকা আপনার ধার ছিল?
আমার 6 লাখ টাকা লোন নেওয়া ছিল ক্যাশ ক্রেডিট।
সুদে আসলে সেটা কত দাঁড়িয়েছিল?
ওটা 20 লাখ টাকা হচ্ছে স্টেটমেন্ট অফ অ্যাকাউন্ট।
আচ্ছা, 20 লাখ টাকা
স্টেটমেন্ট অফ অ্যাকাউন্টসও সেটা তার প্রচন্ড।
এবার আপনি লোনটা নিয়েছিলেন, কতটা জমি মর্টগেজ দিয়েছিলেন?
6 কাঠা জমির ওপর।
6 কাঠা জমি, বাস্তু জমি 6 কাঠা জমি মর্টগেজ
এবং
দিয়েছিলেন।
3 স্টোরেড বিল্ডিং ছিল।
এইবার ওরা, আপনি যখন শোধ করতে পারলেন না, করলেন না, তখন ওরা অকশন করলো। অকশন করে কত টাকা বিক্রি করলো?
46 লাখ টাকায়।
46 লাখ টাকা।
No, may I appraise your lordship? It is 47 lakh.
No, 46 lakh.
Just a second, sir. May I submit? 47 lakhs 43,763, which is the total sale plus interest.
On the date of sale কত টাকা আউটস্ট্যান্ডিং ছিল? কত টাকা?
এটা উনি উত্তর দিক, তারপর আমি ওনাকে উত্তর দেব।
হ্যাঁ, আপনি ঠিক জায়গায় পেয়ে গেছেন এবার, না? হ্যাঁ,
আপনি বলুন কত টাকা।
এইবার ঠিক জায়গায় পেয়েছেন।
আপনি বলুন স্টেটমেন্টে।
আচ্ছা, on the date of sale how much was outstanding?
কত টাকা স্টেটমেন্টে বাকি ছিল বলুন।
স্যার বলছি।
আচ্ছা, ঠিক আছে, why are we are now talking to cloud?
Yes, your lordship, may I take your lordship to page 27?
You tell the amount.
The amount is 45.
On the date outstanding, not the sale price. Court wants to know on the date of sale how much was outstanding.
Total outstanding, I have to, because the only difficulty is I have to get instructions, your lordship, on this.
Why you waste unnecessary?
স্যার আমি দিচ্ছি নাকি স্টেটমেন্টটা।
হ্যাঁ, কত টাকা বলুন, মুখে বলুন না।
স্যার ওনাদের স্টেটমেন্টটা ভ্যারাইটিস রকম আছে, সেই জন্য তো বলছি স্যার ওনাকে দিচ্ছি আমি স্টেটমেন্টটা। উনি দেখে আমাকে বলুক, আমি ওনাকে স্টেটমেন্ট দিচ্ছি। দেখুন স্যার, প্রথম স্টেটমেন্ট আছে, ওনাকে খুলতে বলুন, যেটা দিয়ে আমার প্রপার্টিটা নিয়েছে ওনারা, সেটা হচ্ছে 31/7/2021। আপনি দেখুন 31/7, পেজ নাম্বার 3।
হ্যাঁ, এইবার চ্যানেলে পেয়ে গেছে।
পেজ নাম্বার 3 দেখুন।
31/7
এনি স্যার,
31/7 কত আপনি বলুন। আচ্ছা, আমি কাগজ দেখবো, আপনি মুখে বলুন না। আপনার আচ্ছা, কত টাকা বলুন, কত টাকায় বিক্রি হয়েছে 47, আর কত টাকা সেই দিনে, কত টাকা সুদে আসলে দাঁড়িয়েছিল হয়েছে?
প্রত্যেকটা স্টেটমেন্ট এক এক রকম আছে, আপনি দেখুন আপনাকে দিয়েছি
স্টেটমেন্ট। ঠিক আছে, স্টেটমেন্টটা
কত টাকা ওনারা পাবেন।
স্টেটমেন্ট আজকে যদি কোনো ব্যাংকে আপনার লোন দাঁড়ায় 6 লাখ টাকা, এবছরের সুদ পরশুদিন যখন যাবেন তখন দুদিনের সুদ ওরা ধরে নেবে
100%।
হ্যাঁ, এটা তো কারণ না। আবার যদি 1 মাস পরে যান, আবার দুদিনের সুদ
100।
তাহলে আজকে যদি 6 টাকা হয়,
10 টাকা হবে, সেটা কালকে 10 টাকা হোক, কোনো আপত্তি নেই। কিন্তু আপনি আজকে আমাকে বলছেন আপনি আমার কাছে 6 টাকা পান, 2 মাস বাদে সেটে গিয়ে হয়ে যাচ্ছে কখনো 12 টাকা, কখনো 11 টাকা, কোনো টাকা 10 টাকা। আমি কোনটা মেনশন করবো, কোনটা বুঝবো? আমি আপনাকে জন্য
আচ্ছা ঠিক আছে, এইবার 47 লাখে ওরা বিক্রি করেছে। বিক্রি করে সেই দিন ওরা কত টাকা অ্যাডজাস্ট করে কত টাকা আপনাকে কিছু টাকা দিয়েছে?
কিচ্ছু না।
May I appraise your lordship?
May I know, you now show you the report on the date of sale, how much was outstanding? The only a question, don't show any law or anything,
The lordship.
and longest argument. You just show on that date how much was the outstanding.
May I?
Only a simple query from the court. You give this answer.
The claim, your lordship, the claim I have to show. The claim has been filed. Then I have to come back.
You get prepared and think.
The only difficulty is
unnecessary waste of judicial hour.
Your lordship,
Sir,
may I?
could have disposed of another matter.
Your lordship, may I appraise your lordship for once? Your lordship kindly hears it. Your lordship, whatever.
আপনি এক কাজ করুন, হয় আপনি কাউকে দাঁড় করাবেন
লয়ার দাঁড় করাবো আমি দেখছি আমার কিছু ফিনান্সিয়াল প্রবলেম আছে স্যার। ঠিক আছে,
ফিনান্সিয়াল প্রবলেম নয়, আপনাকে কেন বলছি শুনুন, আপনি কিছু মনে করবেন
না আমি মানছি লতে প্রবলেম।
আপনার অবশ্যই অধিকার আছে, সুপ্রিম কোর্টও আপনার এই অধিকারকে স্বীকৃতি দিয়েছে, কিন্তু ঘটনা হচ্ছে যে যখন লয়ের অনেক শক্ত ব্যাপার হবে তখন তো ব্যাপারটা বুঝতে পেরেছেন তো। হ্যাঁ, চিকিৎসার ব্যাপারগুলো ডাক্তারবাবুরাই ভালো বোঝে।
এটা আমি মেনে নিচ্ছি,
আমরা ছোটখাটো ওষুধ দিতে পারি
না, আমি অস্বীকার করছি না স্যার, কিন্তু এনারা যে জায়গায় আমাকে দাঁড় করিয়েছেন আমার ফ্যামিলি চালানো খুব দুষ্কর।
Appraise your lordship once. Your lordship kindly comes to page 46 once. Just a second, your lordship.
স্যার আমার একটা অনুরোধ ছিল ছোট্ট।
He has created a third party interest during my equitable mortgage being created without any intimation whatsoever. He has created a third. In the meantime, when
you give answer one query, thereafter
I
another.
shall come back on the point.
How much was outstanding on that date of sale?
Your lordship, only thing is, I am on the maintainability of the writ petition. This is my only prayer before your lordship today. Whether my question, I'm putting a question to myself, your lordship, whether this court in its constitutional jurisdiction can entertain this disputed question, how much was the valuation or whatever it is. It has to be decided by the tribunal, your lordship. There's a provision of appeal, your lordship.
Where?
The recovery tribunal, there's a provision under section 30. If he have to avail any challenge, I'm not on the merits at all. Any challenge, he has to approach the tribunal in accordance with your lordship. This is my humble submission, your lordship.
So due to the provision of appeal, lead court cannot.
No, I'm not saying, your lordship. The only thing that is my prayer.
Willful judgment.
Yes, no, according to my very little knowledge of the.
You bring that report means calculation sheet, payment of the schedule of repayment. What is called schedule of repayment, where from it would be reflected that on the date of sale how much was outstanding.
Yes.
How much
Statement
amount
of accounts
was outstanding.
As your lordship.
Your Honor, একটা জিনিস আমি দেখাতে বলবো, ব্যাংক আমাকে টাকা নেওয়ার জন্য একটা চিঠি পাঠিয়েছে, দেখুন সেখানে কোনো অ্যামাউন্ট লেখা নেই, শুধু একটা চিঠি আপনি এসে চেক নিয়ে যান। আমি কি চেক নেব? তার সমর্থন স্টেটমেন্ট অফ অ্যাকাউন্টসই ক্লিয়ার নেই। এমনকি ওনারা ডিআরটি
চেক অফ হুইচ অ্যামাউন্ট,
কোনো অ্যামাউন্ট লেখা নেই। এবং ডিআরটি থ্রিতে আমি একটা আইএ ফাইল করেছি দুটো, মানে ওনারাই চেষ্টা করছেন 11/7/2023 থেকে দুটো আইএ ফাইলে উত্তর দিতে পারছেন না, টিল লেট।
Your lordship then kindly expedites the hearing of the IA. Then if his grievances is there before the DRT already, then kindly expedite the IA will hear that. Let the DRT. Just a second, sir. Let me complete.
Complete করুন।
Your lordship then expedites the hearing of the IA. If he has filed an IA mentioning the similar grievances that is before this court, the lordship kindly directs the tribunal to consider the IA. Whatever the
file IA.
Yes, similar grievances in an IA. Plethora of IAs.
কোনো অ্যাপ্লিকেশন ফাইল করেছেন ট্রাইব্যুনালের কাছে?
ট্রাইব্যুনালের কাছে ফাইল করেছিলাম যখন
one IA has been already dismissed.
Many IAs he has filed over the same cause of action.
Holding that his valuation as his claim was not justified.
Yes, by everything
and baseless.
Yes, your lordship.
ডিআরটি তে যে অ্যাপিলটা করেছিলাম আমি সেখানে
এখন কোনো অ্যাপ্লিকেশন পেন্ডিং নেই।
আইএ দুটো পেন্ডিং আছে ডিআরটি
Yes,
3
your
তে।
lordship.
সেটা কি নিয়ে?
একটা হচ্ছে যে আন্ডার ভ্যালুতে কেন প্রপার্টিটা
Similar
বিক্রি হলো
grievances.
এবং যে স্টেটমেন্ট অফ অ্যাকাউন্টস এর যেটা হয়েছে যে সময় যেরকম ভাবে আছে সেইগুলোকে আমাকে উত্তর দেওয়া হোক, তার উত্তর আজ অব্দি দেয়নি এবং
Direct sir.
যেই পোর্শনটা বিক্রি হয়নি সেই পোর্শনটা আমাকে কেন দিচ্ছেন না 2021 থেকে, তার উত্তর দিন। তার উত্তর তার এখন দেন, 2 মাস টাইম চেয়েছিল ডিআরটি 3 তে অর্ডারে, উনি গেছিলেন, আজ অব্দি উত্তর দিতে পারেনি। ডিআরটি 3 রিকভারি অফিসার আমাকে ডেটের পর ডেট হ্যারাস করে যাচ্ছেন। যে
তাহলে সেক্ষেত্রে আপনার তো এইটা রিট নয়, আপনার হবে 227 করতে হবে যদি একমাত্র সেটা হয়।
বলেছিল আমার যিনি লয়ার আছেন 227 করতে, কিন্তু আমার কাছে তো ফিনান্সিয়াল সেই প্রবলেমটা তো এরা ক্রিয়েট করে
আপনি
রেখেছে।
একজন অ্যাডভোকেট নিন,
না, আমার একজন অ্যাডভোকেট আমাকে হেল্প করছেন, না স্যার আমাকে একজন অ্যাডভোকেট হেল্প করছেন যথেষ্ট হয় ফিনান্সিয়াল দিক দিয়ে,
এটা তো বোঝা
কিন্তু
যাচ্ছে,
তাকে
নাহলে আপনি
দাঁড় করাতে গেলে কিছু প্রবলেম হবে, তাকে তো স্যার ফিস দিতে হবে আমার। এটা তো আমি, তিনি যতই আমাকে হেল্প করুন কিন্তু ফিজিক্যালি যখন দাঁড়াবে তাকে তো আমার ফিস দিতে হবে, সেই জায়গাটা আমার ক্রিয়েট করছে।
দুটো জায়গা আমাদের দেশে আছে, হয় আপনি গভর্নমেন্ট থেকে যাদের দেয়া হয় তাদের গভর্নমেন্ট পয়সা দেবে, ঠিক আছে, আমাদের একটা প্যানেল আছে, সেই প্যানেল আমাদের কেন সব কোটি আছে সারা ভারতবর্ষে, আইদার সেইখান থেকে প্যানেল থেকে আপনি নিতে পারেন, আর না হলে আপনার যাকে পছন্দ আপনার পছন্দ অনুযায়ী আপনি তার
নেক্সট ডেটে আমি
দিয়ে
চেষ্টা করব
আপনি তাকে এনগেজ করতে পারেন। এই দুটো সিস্টেমের বাইরে আর কোনো সিস্টেম নেই। আপনি যদি মনে বলেন তাহলে আমরা এক্ষুনি এই কোর্ট এক্ষুনি কাউকে ওই প্যানেল থেকে আপনাকে যে ভালো হবে, ব্যাংকের মামলা ভালো করে, তাকে আপনাকে দেওয়া হবে। আইদার আপনাকে সেইটা আপনি করতে পারেন, না হলে ঠিক আছে। আর যা মনে হয় তাহলে আপনি তুলে নিয়ে আপনি 227 করুন। 227 করবেন, শুধুমাত্র ওই যে ট্রাইব্যুনালকে বলা যে আপনি যে অ্যাপ্লিকেশন গুলো আছে তাড়াতাড়ি এবং সঠিকভাবে আপনি এটাকে ডিসপোজ অফ করুন। এই 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 ডাইরেকশনটা আপনি কোর্ট থেকে চেয়ে করুন। কিন্তু একটা বিষয়, যদি আপনি একটা ফোরামকে, আমরা বলি ফোরাম, একটা ফোরামকে যদি আপনি বলেন যেটা আপনি বিচার করুন, আবার একটা ফোরামে আপনি জাম্প করে চলে যেতে পারেন, বুঝতে পেরেছেন? তাহলে কি করবেন আপনি? এটা কি আমি ডিসমিস করে দেবো?
আমি লয়ার অ্যাপয়েন্ট করব নেক্সট ডেটে, কিন্তু আমার একটা অনুরোধ ছিল যেটা
হ্যাঁ।
আমাকে লয়ার বলছিলেন, স্যার এই যে রিট পিটিশনটা আছে, আমি একটা সাপ্লিমেন্টারি রিট পিটিশন ফাইল করতে চাইছি, কেন? তার একটা কারণ আছে।
সাপ্লিমেন্টারি
কেন বলছি
রিট পিটিশন?
না না, আমি কেন,
আপনার লয়ার এসে যদি বলে তাহলে আপনি
আর একটা না না, আমি যেটা বলছি তার কারণ হচ্ছে স্যার, যেভাবে এই প্রসেসটা হয়েছে, পুরো প্রসেসটা যেভাবে হয়েছে সেই ব্যাপার নিয়ে একটু আমি কোর্টকে জানাতে চাই, তার একটা পারমিশন আমি চাই। লয়ার দেবো, নেক্সট ডেটে আমি লয়ার দিয়ে দেবো।
Your lordship, that similar grievances before the debts recovery tribunal, your lordship, he has to complete. Your lordship, kindly.
Yes, but there must be transparency in the action of the bank concerned.
That is true, your
while
lordship.
dealing with the property of citizen of a country.
Your lordship,
Many allegations comes off and on against the officials of the bank.
That is there, your lordship. I'm not on credits.
As and when he finds that any property is subject to a equitable mortgage, he thinks that anything can be done.
No, your lordship, may I, your lordship.
Okay.
Only prayer.
6 কাটা 6 কাটা কোথায় জায়গাটা?
6 কাটা জমা শকুন্তলা পার্কে,
ক্যালকাটা।
5 লাখ টাকা কাটা সব শকুন্তলা পার্কে, যেখানে 10 ফুটের রাস্তা, তার থেকে 4 ফুটের 16, সেটা নাকি ল্যান্ডের দাম হচ্ছে 5 লাখ টাকা কাটা।
You on that date, on the other hand, you on that date, come on that date, how much was the court from the very beginning wants to know. It is only to check as to whether the action was transparent or not. There must be some transparency while you are dealing with the property and money of a common citizen of the country.
That is there, but the only prayer before your lordship is
No, you saw. Why are you saying this forum, that forum? You saw that on that date I have sold out the property by auction on 47, and my outstanding was 25. I have deducted that amount. I have paid the rest amount.
Exactly, sir.
Your lordship then grants me.
Since there was no transparency,
and
hence this case has come on.
Lordship grants me some time because it's a RP of 2014. I have.
Why you are raising such sort of technical issue? You show us.
Your lordship.
So whatever forum I shall show. That calculate he took loan of such and such rupees, as on date, along with the interest, accrued interest, the amount stood to such and such, and I have deducted such and such.
As your lordship needs, I shall come back. But your lordship, the only
আমি 2021 থেকে সাফার করছি,
the only
আমি তো রিলিজ করে দিয়েছি আমার পেমেন্ট।
Okay, come on that date.
Okay, lordship, if a longer date means.
And
May I submit? May I submit? It's a 2014 result.
No,
At least a week's,
2014.
at least a week's accommodation. If
One suspicion has created in the judicial mind of this court
as your lordship deems fit, as your
as
lordship.
to whether you are transparent or not. You remove that suspicion.
I
Otherwise, it is a writ court.
I
Can
your lordship
extend
can
its
do
law
anything,
of
your lordship.
anywhere.
Anything that is absolutely,
Article 7 has not given any limitation.
absolutely.
Be aware of that.
Absolutely, your lordship.
You on the next date, so had the learned advocate
I appear for the state, my lord.
I am for the petitioner in this matter.
Mr. Basu Malik is online, my lord.
Okay.
Who's here?
Approval of appointment. As per the recommendation made by the school authority of the. Yes.
This is a selection West Bengal School Service Commission state level selection test for appointment to the post of teachers rule 2015. That will appear at page 22 of your lordship's petition. Malad, the petitioner before your lordship is one of the candidates who participated in a selection process. Thereafter, my lord, what is the rule, my lord, relating to recruitment? I take your lordship to that. First of all.
Page? Oh, first.
That page 33, schedule. Essential qualification, including the professional qualification.
Page 30.
It starts from slightly earlier. Lordship can look at page 22, its rule starts. The schedule is important. Page 33. We are concerned about assistant teacher for the post of postgraduate physical education in English. Page 35.
Assistant teacher for the post of postgraduate
physical
education in school. Yes.
Bachelor degree in general stream of art science with degree diploma in physical education from a teachers training institute duly recognized by the National Council of CTE, Rehabilitation Council of India, RCT. It appears from page 127, the DI's notification. So far as the petitioner is concerned, it is dealt with by the DI and on 10th of August 2020. May I place it for your lordship?
Yes.
Approval of subject is approval of appointment of Subhash Chandra Mondol for the post of assistant teacher in physical education. With reference to the subject noted above, DI of Schools Kolkata has informed that the experience of external expert Manohar Mondol is less than 5 years, which is in violation of law. As per Geo number so and so, the qualification of physical education on teachers is as follows. What is the qualification required? Senior secondary with at least 50% marks from the recognized board, or candidates who have passed the senior secondary examination or its equivalent have participated in sports game at least school, college, district level in accordance with the council for teachers education recognition regulation 2007 noticed on 10th of December 2007. Thereafter again my case is that I come within the purview of candidates, second proviso. Candidates who have passed senior secondary examination +2, 10 +2 or equivalent. But he has a sports background. Sports in the school, college or district level sports. Yes. Now, my lord, kindly skip over why I am rejected. Reason has been given. In the present case, marks of HS examination of first MPLL candidate Subhash Chandra Mondol is 41.7 and has completed training of 1 year, which is violation of rules, violation of law. Hardly second and third candidate, leave aside. We are not concerned about second and third candidate. My case has been rejected on the ground that I got marks, HS examination, past impellent candidate Subhas 41.7. Am I clear?
And completed training of 1 year.
I mean, they want I should be 2 years.
2 years, yes.
Kindly come to the second proviso, page 2127. I have just shown to your lordship.
Yes.
Candidates who have passed senior secondary examination or its equivalent. Now, this 41% comes in first proviso. Senior secondary, 50% marks from recognized board. That is the first clause. A. I come under 2B. Here the percentage of marks is not required. Only passing out is sufficient. And provided I have a training and I have a sports certificate. The school level. School, college, district, whatever, state, whatever level. Now I am combating an issue here before your lordship as to whether 1 year B.Ed qualification undergone by me, they are admitting, is a valid qualification or not.
Okay.
For my recruitment. Now, kindly come to page 130. Well, this is a notification regarding approval of appointment of Subhash Chandra Mondol at the top. It is written. Approval of appointment of Subhash Chandra Mondol. At the top, Miller printed. Immediately.
Yes, yes, yes. Yes.
It is addressed. May I place the first letter? With reference to memo number 316 of 2020, this is to inform you that the school authority has already submitted the first approval of external expert, Monotosh Mondol, as per your objection, as are again sending the approval of Mr. Monohar Mondol as per his first approval dated 16 February 2009. His service experience is about 11 years. As per SSC rule,
yes.
As per SSC rule, 1 year BPEd, that is equivalent to B.Ed, Bachelor of Physical Education, and Bachelor of Education for general. I have the physical education. 1 year BPEd course is allowed those candidates who got degree before 2015. So 1 year BPEd was valid up to 2015. Thereafter, 2 years. I completed BPEd in 2013. Lordship will get it at page 50.
Page
50. Bachelor of Physical Education. My degree. This degree of Bachelor of Physical Education,
Yes.
1 year degree.
2013.
Is summer 2013. So I squarely not covered with the condition of two years B.Ed. Now next letter also at page 30 with reference to your mail P16 10/8/2020. This is to inform that the school authority has already submitted approval of external expert. Next, as per SSC rule, 1 year BPEd court is allowed. Again,
show that rule.
I am showing. I'm showing you. Now, let me straightway come to the rule.
Yes.
Let me straightway come to the NCTE rule. That is the best rule covering the issue. That starts from page 155.
Yes.
Kindly come to page 167.
Yes.
Duration. Kindly come to the norms and standard of Bachelor of Physical Education at the top in a box, leading to Bachelor of Physical Education BP8 degree. The BP8 program shall be of a duration of 1 academic year or of 2 semesters, 6-month semester in 1 year. So it is no more an issue to be adjudicated here. The DI has absolutely, my lord, at fault in holding that I need a 2 years B.Ed course. 1 year B.Ed course is a valid course as per the NCT own norms. Now kindly come to another National Council of Teachers Education, page 181, NCTE regulation of 2009.
Yes.
It starts at page 181. Kindly come to page 185. Duration. Duration. The BP8 program shall be of duration of 1 academic year or of 2 semesters.
Yes.
So 1 year BP8 cannot be said to be invalid in training qualification.
Training qualification. Yes.
Now, so far as the decision taken by the authority denying my approval, according to me, my lord, is nothing but total non-application of mind.
Yes.
So far as the court certificates given by the petitioner, আমাদের reply টা দিয়ে just we have given a reply to their opposition.
Yes, yes. থাক ইয়ে নিয়ে নেবেন পরে।
Well, I would be requesting your lordship to take up my reply because I have given serially. There are sports certificate here. All the series of sports certificate has been given. Kindly come to page 137 of my writ petition. 137 of the writ petition.
Yes.
This is a sports certificate, state level, school level, district level is admissible.
Yes.
This is a West Bengal level karate championship. Asian Martial Art Federation is giving me that I have participated here and secured 6th position in the 55 to 60 kg. Well, this issue has not been, my lord, highlighted so far as my eligibility to be a sportsman to get the advantage of second proviso in the impugned order. They have only highlighted that you are not B.Ed of 2 years. If I had the B.Ed of 2 years and 41% marks, my lord, is not a bar if I am participating in a sports in accordance with their own guideline.
So there is no question that you have represented or participated in any game at the state level or district level.
District level.
It is state level certificate.
It is state level.
Maybe West Bengal, Tasi, Goju.
Asian level, Asian Federation has given it.
Huh?
Asian Federation has given it.
Oh, basically it's a local club certificate. It cannot be any district or national. It's a local club. Kindly go through this once, my lord. Who has issued it? Is there any affiliation unit? No, my lord. It's a local club has issued one competition. He has participated in a
Affiliated
karate
to
competition.
Asian Martial Arts Federation.
Well, that is, my lord, that is a competition name.
They wanted
Like
to
an
verify
under
it.
19, under 16,
They
like that.
wanted to verify it. But I have not been disclosed what the result came out. In their affidavit, they say that we wanted to verify it, but we did not know what is the result came. But that issue is not an issue for rejection of my claim. That issue has not been made an issue in rejecting of my claim. My claim has been rejected only 1 year be it. Therefore, by affidavit, they can improve it or not. That is also a matter, my lord. I shall be citing judgment on that.
Yes, a judgment. There is a judgment. Yes.
You cannot by affidavit.
Affidavit,
say,
you cannot improve
your defense. 1 year B.Ed goes. Therefore, I come to the second proviso. They have only rejected my claim that you are not entitled because of our 1 year B.Ed. So I should be I am entitled to an approval of a May appointment.
But if court notice this thing, can court certifies?
I have given notice to court. I have given the bunch of certificates I have obtained.
No, whether you participated in any game, what is the main? They are called meritorious sports person. Meritorious sports person, MS category, MSP category in here. So he is to participate in any game, district level, state level, national level. Lastly, most probably the state omitted district level. Now state and national level. Then only meritorious sports person. That benefit has been given.
That they have not said that you are not.
They have not said so.
Have they said so? Kindly come to my
yes, I have noticed.
I'll look at my affidavit in reply for once.
Yes.
My Bachelor of Physical Education certificate is 1 year degree course is annexed. Thereafter, West Bengal Open Yoga Competition 2016 is given certificate of participation. Thirdly, Yoga Fest 2017. Fourthly, physical training camp organized by the Sports and Youth Service Department, Government of West Bengal. Page 10, Lord Subil, kindly mark it.
All Bengal Yogasana Competition.
Kindly come to page 10, 110. Physical training camp organized by West Bengal Sports Youth Services Department, Government of West Bengal. West Bengal Council of Sports, West Bengal Board of Secondary Education. It is a sports level program I have participated.
Page 10.
Page 10 is a state-sponsored organization. Kindly come to page 15, 1-5. Page 15, the certificate given by Sensal Devasis Kumar Das, Chief Instructor, Director, Goju Rao Karate Do, West Bengal. He has said it is affiliated to Asian Martial Art Federation, and our organization is holding every year the karate competition, an award certificate of state level competition with our seal and official signature on official. And language given, my lord, by in the recruitment notification. This is a writ petition from 2022 pending. They have not approved my appointment, for which I have to move the Honorable High Court for writ.
Whether the SSC rule said that 1 year training qualification will be accepted.
NCT is saying.
NCC may say, but whether.
My lord, page 52, kindly come for once. Kindly come for once.
Yes.
Page 52.
Yes.
University of Kolani, a certificate is given. Obtained degree of Bachelor of Physical Education in the university in the year 2011 for fulfillment of the prescribed requirements, and that he placed in the second class. This is a Bachelor of Physical Education 2011, a 1 year course.
Biplav Hasda.
Biplav Hasda has been given appointment, page 51. I participated in summer 2013. Lordship has seen in my certificate I have mentioned. Page 50, kindly come for once. Same writ petition. Page 50.
50.
50.
Hmm.
This
What?
is given in favor of one Shompa Shoibbo, daughter of Sadhukha. Having passed the examination for the said degree in summer 2013 and was placed in the first division. 1 year degree course. Kindly come to the second line of the degree. 1 year degree course. And kindly come to page 49. Shompa has been given appointment with 1 year degree.
Yes.
Shompa's name will be appearing immediately down the middle. Shompa so and so, roll number so and so, correspondingly date of birth so and so, everything. So similarly situated persons who had already been given appointment, however, why you are raising the issue for me? This particular course we have conjointly done. Page 50 and myself in the same course.
Yes.
This summer 2013 was a course undertaken by me. And summer 2013 another has been given, and in my course you are saying that you are 1 year B.Ed. So far as the other issues they have raised, I will be relying on the Maninder Singh Gill's case. The celebrated judgment lordship knows that very well.
Affidavit. Defense cannot be improved by
affidavit. That reason given in the affidavit. This is bad, this post bad. But that is not the reason they have rejected my case. When a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reason in the shape of affidavit or otherwise.
Yes.
My prayer is only to cancelling the order dated 10th of August 2020 by the DI and to accord approval to the appointment of the petitioner. That's my case.
You are for?
My lord, I am for the state.
State. Along with Mr. Bosumoli.
Along with Mr. Bosumoli.
Yes.
Let him do it. Let him do it. He has all the documents. I don't have all the documents.
Okay.
He has all the documents.
Okay.
My lord, the petitioner was given appointment, my lord, as a teacher in physical education, my lord, in the year
I am to assist you.
My lord, kindly come. My lord, the petitioner was given appointment as a teacher in physical education, my lord.
You want to say year?
Yes, my lord, on 4th of January 2020, my lord.
4th of January
2020.
Yes,
2020. Yes, my lord. My lord kindly comes to the rules, my lord, which my learned senior friend has cited, my lord. The rules are in my opposition, my lord, at page 10. My lord, these are the applicable rules of 20th September 2016 in this matter.
Yes.
My lord kindly comes to page 18, which is the relevant portion.
Yes.
My lord kindly comes to part B. My lord, I am placing.
Yes, part B.
Yes. Educational qualification, including professional qualifications for selection of assistant teachers for physical education and work education for upper primary level classes in schools. My lord kindly sees the conditions. A. First condition is, my lord, senior secondary class 12 or its equivalent.
He is not coming within that. He is
But it is an admitted fact that he is not coming in the first or the third point.
Yes, the second is
The second is the disputed. And the second part, my lord, is the and provision. And certificate diploma in physical education.
And have participated.
And duration of not less than 2 years, my lord. I am not coming to the second part of 2 years for now, my lord. Because, my lord, if the first qualifies, then, my lord, the second comes into effect. It has to be either of the first three and the second one. Assuming but not conceding, my lord, the 1 year is applicable, I am just going to, my lord, the certificate, my lord. Only one sports certificate, my lord, is annexed to the writ petition in annexure P13, my lord, which is at page 137. My lord, this is the we have tried, the state has tried, my lord, to verify whether this is the certificate of a state.
This is not a ground for rejection. Don't waste time on this. This issue is not here. I have not addressed the issue. I should not address the issue because this is not a ground of rejection.
My lord, we have tried to verify, my lord. Kindly comes to page 25 of my affidavit in opposition, my lord.
Yes.
My lord, we have written to this Sensei Goju Karate Dio West Bengal, my lord, whether they are affiliated. My lord, may I place the letter? With reference to the subject noted above, the District Inspector of Schools, Kolkata, has the honor to inform that the Subhash Chandra Mondal submitted an application to the School Authority of Kaurapukur CNI Boys High School, Purbo Putiari PS, Regent Park, Kolkata 93 in July 2019 for appointment as assistant teacher in physical education. It may be intimated that the same was sought from this end by this office memo dated so and so 8/10/2021, but unfortunately no response has been received till date from your end. Under the above circumstances, you are further requested to kindly provide the information regarding the following matter: whether the certificate of merit in favor of Subhash Chandra Mondal is of school, college, or district level with the NCT Regulation Norms and Procedure 2007 notified on 10th of December 2007, photocopy of recognition, and whether the organization is affiliated to the Sports Authority of India. That apart, my lord, the next page, my lord, the 8/10/2021 letter, which was referred to in the previous page, my lord, is also given. My lord, after these letters, my lord, no response has come to the District Inspector of Schools. My lord, so the second proviso, which my learned senior friend is relying on, my lord, that could not be verified. And that certificate, my lord, whether it's of a state, college, or district level, my lord, could not be verified. My lord, my learned senior friend has relied on certain, on this letter, my lord, which is appearing at page 15 of my learned senior friend's affidavit in reply. My lord, this only is a letter, my lord, issued by The chief instructor director, my lord. This is of no official authority. And so far as the second 2 years requirement is concerned, my lord, I have dealt with it in my affidavit in opposition. My lord, kindly comes to page 7 of my affidavit in opposition. I have stated, my lord, both with regard to the certificate and with regard to the 2 years, my lord. Let me place. I say that in the absence of proper clarification with regard to the authenticity of the sports certificate and clarification whether the said sports certificate is obtained by the petitioner to fulfill the second condition of clause A of part B of schedule 1 of the rules of 2016, no approval of appointment could be accorded in favor of the petitioner. My lord would recall, my lord, there is an and provision, either of the three and the second portion. And that was also provided in the reasoned order. And the second, thereafter, my lord, I say that the petitioner is not eligible as per the conditions of clause A of part B of schedule 1 of the rules of 2016. The second condition of clause A of part B of schedule 1 of the rules of 2016 is yet to be verified. That apart, either condition of clause A along with clause B of schedule 1 of rules of 2016 has to be satisfied. The petitioner has completed training of 1 year, which is in violation of the rules of 2016 and does not satisfy clause B of part B of schedule 1 of the rules of 20, which is a mandatory requirement. So, my lord, I have stated on affidavit that this 2 years requirement is a mandatory requirement. My learned friend, my lord, has placed some main city guidelines, my lord, whether those are applicable, my lord. My instructions at the time of affidavit was that they were not. My lord, my learned friend has also relied on page 130, my lord, of these communications. My lord, these communications state SSC rules of 2015, my lord. Those were not placed, my lord, before my lord.
Yes, I understand. It is a letter. Rule 15.
Yes, my lord. At page 130, my learned senior friend has placed an email which states, my lord, that as per SSC rules, 1 year BPEd course is allowed to candidates who got degree before 2015, my lord. So this was the communication given to my learned.
It is a communication rule.
Yes, my lord. But the rules were not placed, my lord. And as per my instructions at the time of affidavit, my lord, the district inspector has stated, my lord, that this 2016 rules is the applicable rules and the 2 years course is the mandatory provision. Even otherwise, my lord, the entire rules were quoted in the reasoned order and that provision was mentioned regarding the sports certificate, my lord, and the authenticity required for the same. And my lord, the sports certificate, my lord, is not authenticated.
But Mr. Bhattacharya says that court cannot take cognizance of that count.
My lord, I have to then deal with that judge.
And showing the judgment of Moninder Singhil. Moninder Singhil, nothing that no one will be permitted to develop his defense by filing affidavit.
My lord, I am not developing the defense.
Laid down in Moninder.
My learned.
So you have rejected on 2 counts that he got 41.7% and he has he has 1 year B.Ed qualification, BPD qualification.
My lord, my humble submission is, my lord, that, my lord, the rejection was not only on the basis of the 1 year B.Ed, my lord. The entire rule was quoted. Only in the last sentence, my lord, it has been stated that 41.7 he has obtained, my lord, and 1 year B.Ed, my lord.
That's the ground of rejection.
The sports certificate, my lord, at the time of passing of the reasoned order, these clarifications has not come. And that's why, my lord, possibly in the reasoned order that did not appear. However, my lord, in the reasoned order, the entire rule was quoted. It is not that it was completely in the dark. It was completely given a go by. And my lord, if my lord permits, my lord, I may deal with the judgment on another day, my lord, if my lord is so.
There is no judgment against. He is speaking of the School Service Commission rules. Kindly come to page 138. School Service Commission rules. I have annexed. 2016 rules.
Yeah. 11th portion, the training.
Yes. Kindly come to page 140. Professional qualification. 1 year B.Ed. Professional qualification, clause U. Except physical education and work education, 1 year bachelor degree. And physical education, work education, even consistently said.
One year bachelor in education. One year
bachelor in education. I have done 1 year
Yes.
bachelor in physical
No,
education.
you have done physical education.
Physical education is work education. Physical education against the work education, it is called physical education.
It is you is professional qualification except physical education and work.
The physical education has not been dealt with, but 1 year training course has been accepted.
No, it is professional qualification except.
1 year training course has been accepted. NCT has accepted it. 2007. Lordship will get it. NCT accepted. Page 155. I have shown it to your Lordship. Kindly come to page 163. Norms and standard of Bachelor of Physical Education. Page 163, clause 8, Roman 8. I want to conclude the hearing today. I don't drag the matter. I would request you. So already I have made your Lordship late. Only this should be noted. Page 163, clause 8. Norms and standard of Bachelor of Physical Education program leading to Bachelor of Physical Education BPEd course. Has your Lordship got it? Appendix 8. Appendix 8 is Lordship will get it here. Appendix 7, not 8, Appendix 7 at page 185. Appendix 7, 185. Physical education is dealt with by the NCT Bachelor of Physical Education. It is mentioned in Appendix 7. Appendix 7 is at page 185. Duration of BPEd, 1 year. Who else will say it? NCT is saying it. That's why the SSC said that NCT since has said about the work education and physical education, we are not dealing with this particular issue. I have shown your Lordship that. I will not travel further, your Lordship, on this. Kindly note it and Lordship reserve it for judgment.
Reserve for judgment?
Yes, and nothing further to be said. Enough is
Or for order, under the heading for order.
Lordship. 2 years, as per DI, my junior has said, my lord, in my affidavit, I have categorically held.
Junior যে বলবে তাই হবে। আমার কেন বলছো? চুপ করো।
Your junior has seeking a further time to deal with the judgment of decision of Mahinder Singh.
His judgment.
That is up to his lordship, my lord. Yes, my lord.
Huh?
Leave it
That
to
is
my
Mahinder
lord.
Singh's judgment, my lord.
The judgment to your Lordship.
Lordship can, but his lordship can, lordship cannot shut his lordship's eyes, my lord. Because, my lord, this is the issue, my lord.
Having the good eyes.
In the recent order, my lord, the entire rule has been quoted. It is not that we have not dealt with, my lord. Entire rule has been quoted. We have not have the document, that's why it has not been reflected. But the rules, whatever the rules is, that has been quoted. And 2 years he has not crossed. NCT has never said that it has to be 1 year is complementary. It should be 2 years. That's the precise, my lord, the submission that we have made before his lordship. And it has been mentioned in our affidavit also. my lord.
Where from it would be evident it is 2 years?
My lord, from the rules itself.
No.
From the rules which we have cited, my lord,
I have cited.
it says 2 years.
Oh.
They have cited rule, SSC rule does not deal with the work education and physical
It
education.
says 2 years, my lord.
16
And
rules.
NCT is not party in this matter, my lord. If it is the rules of NCT, then NCT should have made party in this proceeding, and NCT would clarify before his lordship whether this is a 1 year or 2 year. That would suffice the entire issue.
Yeah. The
Unnecessary
unless
dragging
advocate
the
defending the respective parties have concluded their argument, ঠিক আছে? Judgment দিতে হবে।
Grateful, deeply
Grateful, my
grateful. I'm grateful.
new unit to be entitled to get subsidies, some registration has to be obtained. And that registration is in two phases.
Registration through?
Registration is in two phases.
Two phase, yes.
First is first stage registration certificate 1. Once I get registration certificate 1, then again I have to apply for registration certificate 2 within certain days from the date of commencement of commercial production. Here, my lord, registration certificate 1 has been obtained. Thereafter, I have applied for registration certificate 2.
Within that time?
Yes. Now, that is the dispute which they have raised. Therefore, my lord, if I show your lordship 2-3 clauses, your lordship will get what is the dispute between the parties, my lord. Kindly take the scheme. If your lordship sees page 36, this is the actual scheme which is in operation.
Yes.
And it's a short title. This is known as West Bengal State Support for Industry Scheme 2013, as amended up to 12 September 2014. Now, your lordship will come to the definition of a new unit under 3.12.1 at page 39.
Yes.
A unit in the large-scale sector for manufacturing goods in West Bengal for the first time, which starts commercial production on and after 1st September 2013 and is registered with Director of Industries. So, registration is to be with the Director of Industries. Now, if your lordship sees 3.15, registration certificate. This is the definition clauses. Hereinafter referred to as RC means final registration certificate issued by DI in RC Part 2, certifying first date of commencement of commercial production and preceded by preliminary registration certificate issued by DI in RC Part 1. So first is RC Part 1, then is RC Part 2 with the final registration certificate. Then, my lord, kindly see 5.2 and 5.3. These are the only two important clauses. 5.2 is at page 41. A unit shall be required to submit application in form number 1 to DI for registration of the unit for being qualified for incentives under 2013 scheme. Form number 1 shall be submitted online. So first I have to submit it online. Requisite fee. Upon successful submission of the application online, hard copy of the same form with acknowledgement generated by the system shall be submitted within 15 days to DI along with relevant documents detailed in Form I and duly filled in the checklist. Now, my lord, kindly see 5.3, which is the most important clause for our purpose. Shall be required to submit application in Form 1 capital A to the DI for RC Part 2 within 30 days of commencement of commercial production. However, the date of effect of all the admissible benefits under this scheme shall be the date of commencement of commercial production or the date of issue of last statutory clearance, whichever is later. Then, well, the procedure is same, first online, then offline. Now, my lord, kindly see here, 2-3 dates are important. My application for RC1 that was given on 6th of January 2014.
RC1 was given.
I have made an application for RC1. The date is 6th January 2014. Now, my lord, RC1 was issued on 7th August 2015.
Yes.
Kindly come to this document, which is at 115.
Yes.
Kindly see the top, my lord, registration number part 1, date is 7th August 2015. This is the date of issuance of RC1. At the top, your lordship will find just after Government of West Bengal Directorate Industries registration certificate part 1. Your lordship has gone.
Yes.
Then kindly see next, first date, 7th August 2015. This is the date of issuance. Next column is online application. So 31st December 13 was my online application date. Now kindly come to column 12. Expected date of commencement of commercial production. 15th June 2014. So when I made the application online on 31st December 2013, that is the prospective date which I had mentioned. And in fact, as a matter of fact, my lord, commercial production had commenced on 4th September 2014. Not on 15th June, that was the expected date. It actually commenced on 4th September 2014. Now, thereafter, my lord, there was a corrigendum issued to this RC1. Schedule of land was amended. That was issued on 14th of October 2015. So, after this corrigendum issued, that became final RC1. Now then, my lord, after this RC1 comes, I could apply for the RC2. Why I tell your lordship? If your lordship sees the application form for RC2, which is at page 120,
yes,
kindly see 1C. 1A is applicant, village, then C. Number and date of preliminary registration certificate, part 1. So therefore, until and unless I get the RC part 1, I cannot fill up this form. So this presupposes that I have to wait till I get RC1. Now lordship comes back to that clause 5.3. 5.3 does not expressly provide for this particular fact. But kindly see, it only says unit shall be required to submit application in form number 1 capital A. That is the form I showed your lordship. 2DI for RC part 2 within 30 days of commencement of commercial production. They are not saying here any date from issuance of RC1.
From the commencement of production.
Yes.
According to you, 4th September. It will be from 4th September.
According to me, I may have commenced on 4th September. But RC1, until and I get the RC1 in my hand, I cannot actually apply for RC2. Because I have to put in the number, date, everything of RC1.
Which you got on 14th October 2015.
Right. Malad, kindly also see why I am saying this. This is to be read into this clause because kindly see 3.15 once more at page 39, where the definition of the registration certificate is given. 3.15 registration certificate hereinafter referred to RC means final registration certificate issued by DI in RC part 2 certifying first date of commencement of commercial production and preceded by preliminary registration certificate issued by DI in RC part 1. So therefore this presupposes that I must have a preliminary registration certificate in part 1, then 30 days will be counted from commencement. So here is the dispute in this case. Here, my lord, after I have submitted this application form, then, my lord, they issued a...
And when you have submitted?
That is the date, my lord. Kindly see application. And date ta kothay?
Application for RC Part 2.
Kindly come to page 122. The date is mentioned at the bottom after the declaration. 30th September 2015. And the hard copy of it was submitted on 14th of October. Still, I'm 30 days in Mukti.
So before receipt of final, according to you, final RC1.
After.
Why after? You corrigendum issued here, you finally you have got RC1 on 14th October 2015.
Yes.
And you applied for on 30th September 2015.
Because at that point of time, I already got the original number of RC1 on 7th of August 2015. Only the schedule of land was changed by the corrigendum.
Yes.
But I had the RC number on 7th of August 2015.
Yes.
Now, my lord, there is this dispute. After I have submitted everything, then kindly come to page 130. This is their document dispute which is raised by them for the first time.
Yes.
28th June 2016, their document, they say, with reference to above, your request to clarify the ground of claiming the date of commencement of commercial production in the month of September 2014, when the date of issue of first invoice was 27th of March 2014. Then, regarding non-compliance on your part with para 5.3, it may be noted that there is no bar in the scheme 2013 in applying for RC2 without RC1. Statutory clearance as mentioned in 5.3 is related to commencement of flow of incentive under 2013 scheme and not with submitting application in Form 1A. This issue will be referred to the department for a decision. Now, my lord, kindly see. Yes. If your lordship kindly comes to my letter at page 129. I have already clarified this.
Yes.
Kindly see, we enclose certain documents, then in second paragraph, as regards. You are asking for us for clarification on our submission date for RC Part 2. Please note that we physically received RC Part 1 from you on 24th August 2015. Wide your communication dated 7th August 2015. As per clause 5.3, the date of effect shall be the date of commencement of commercial production or from the date of issue of last statutory clearance, whichever is later. Since we received RC1 from you on 24th August 2015, effective date shall be 24th August 2015. Therefore, our submission online on 30th September falls within the stipulated 30 working days. This was our clarification already given to them. So, now they said that they will refer it to the department for a decision. The matter was they did not take any decision. There was a writ petition filed, writ petition disposed of, directing them to give a hearing and pass an order. This order, my lord, is what we have challenged here at 149A.
Yes.
Kindly come to second last paragraph on examination.
Yes.
On examination of the application. For registration certificate Part 2 and other documents submitted by such and such, it is found that company has submitted their application registration certificate Part 2 after more than 1 year from the date of commencement of commercial production. In contravention of clause 5.3, company claimed after more than 2 years while received by this office on such and such that immediately after commencement of commercial production, they had tried to submit application for registration certificate Part 2 online, but could not do so for want of registration certificate Part 1 number and date of issue. It is noteworthy to mention here that registration certificate Part 1 was issued on 18th August 2015 that is within 1 month of submission of all requisite documents by the company on 23rd July 2015 as per provision of 2013. But their claim that they had actually tried to access the system could not be verified. As WBITC informed, there is no such provision on the website to check the failure status while making application for registration certificate. Company had also never communicated with their reported problem of online submission for registration part 2 and did not seek accommodation of physical submission. The problem of online submission actually existed as claimed by the company. Now they have rejected my application on this ground of 5.3 alone. Now kindly see what is the reason given. Reason given is that I did not approach them to submit physical copy. There is no provision in the rules for submission of physical copy. They had to only decide this fact whether this, as I showed your lordship, the online application has a particular format. I cannot keep that serial number 12 blank. If I had kept it blank, where RC number and date is to be mentioned, then it will be rejected automatically. So, my lord, automatically it means that I have to wait for issuance of RC1. Then within the 30-day period, I will apply. That is what I have done. So, my lord, this is only the limited extent of judicial review of this order. But I think, my lord, your lordship will have to hear the other side. They have not used any affidavit, but affidavits are not necessary because, your lordship, they have to justify this order on the strength of the scheme. Affidavit, they cannot improve their case. I think, my lord, your lordship can fix a peremptory date. I will give them further notice and I will intimate them that your lordship has heard the matter. Your lordship can record my prayer submission and we can communicate your lordship's order to them.
Justifiability of the order dated date. Where is the date?
Well, the date is
to perform extensive indoor and outdoor duties. The final selection would be made on the basis of the aggregate value of written test and interview. The petitioner sat for the written test held on November 6, 2022. Mr. Sachin Sai, learned advocate appearing for the petitioner, submits that after the written test was held, the selection process of to the post of the traffic superintendent was changed by the joint managing director, West Bengal Transport Corporation Limited, via circular dated 6 June 2023. Pursuant to the said circular, a maximum of 30 marks would be awarded for experience in the rank of ticket inspector cum starter or senior rank at the rate of 2 marks per completed year of experience in the above mentioned rank, and minimum 10 marks would be awarded to those who have a satisfactory record during the last 5 years with no punishment awarded pursuant to the disciplinary proceedings or previous ban or promotion. But this entire process, this is the induction that has been made after issuance of the selection process. We, the writ petitioners, appeared in the written test. After the conclusion of the written test, but before the interview being taken, this incorporation was being made and a challenge was thrown before your lordship. Prospective candidates were required to secure a minimum of 27 marks out of 90 marks. Aspirants who qualified to the above mentioned stage were to be called for interview for 10 marks. The written tests were concluded only on 50 marks as per the parent notification dated 16 June 2022. But thereafter, direction was given to file a report in the form of an affidavit. If my lord may kindly sees how the rule of game has been changed after issuance of the selection process. If my lord may kindly takes up the writ petition.
Yes.
This is the parent notification at page 18.
Page 18, yes.
Parent notification at page 18, it is dated 16th of June 2022.
Yes.
May I read out the entire notification? It is relevant. Notice inviting application for promotion to the post of traffic superintendent. We were initially joined as conductor. We were promoted by usual course to inspector. Those who were officiating in the post of inspector, they were made eligible to apply for the post of traffic superintendent pursuant to this advertisement. It has been decided to fill up 16 posts of traffic superintendent on the basis of merit cum seniority from the aspirant staff members presently holding the rank not below the rank of traffic inspector, inspector cum starter, who are in 5 years satisfactory service in the post. Eligible criteria and reservation of the post is stated hereunder. But these are the 4 criteria which I have read out to your lordship, which has been reflected in the order of the coordinate bench of dated 21st of April 2023. Now, my lord may kindly come, the last date of application is given. Thereafter, applications are invited from the eligible candidates. As per eligibility criteria, candidates shall have to pass through a written test followed by personal interview of the candidate in the order of merit list of the written test in the ratio of 1:5, subject to scoring the qualifying marks in the written test. All the application in the prescribed format would be received at the office of the deputy managing director in between such and such working hours on every working day up to last date as mentioned above. Prescribed format will be available at the Esplanade Traffic Office, Head Office, Traffic Department. No application shall be valid without supporting educational certificates and caste certificates if applicable. Copy of the document should be self-attested. Now kindly see the last line. Final selection would be made on the basis of aggregate value of the written test and interview.
Yes.
Now, my lord may kindly comes to the next page at page 19. Kindly see the last paragraph. Second last paragraph. It starts, second last paragraph, kindly skip the first 2 lines. If an applicant does not fulfill any of the conditions of the eligibility, his candidature will be cancelled. But the eligibility refers to the parent notifications of 16th June. Now the last paragraph. Marks of written interview, multiple choice question, MCQ of 40 marks. Report writing ability 10 marks. So total 50 marks. Duration 1.5 hours will be allotted to answer the question. Examinee shall have to report at such and such venue and admit with admit cards. Now there is a stipulation that no electronic gadgets will be carried out. Now my lord may kindly comes to the next page, page 20. My lord will see the name of the candidate.
Provisional admit card, yes.
Provisional admit card. Name of the candidate, Gobindo De. Gobindo De is one of the writ petitioners. There are 2 writ petitioners. The Gobindo De is one of the writ petitioners. My lord, he was directed to appear for the written test. My lord, next page.
Interview letter.
Yes, interview to be held on 19th of January 2023 at 12:30 hours in the conference hall. So I was being called for interview after I have been made eligible in the written test. Now, the impugned circular, which is under challenge. Page 22. But here, by this notification, entire rule of game has been changed. I was being supposed to play a football, now I find it is a basketball.
Yes.
In the terms of notification, White memo number such and such dated 16th of June 2022, but this is the parent notification. For filling up the post of 16 traffic superintendent, 87 aspirants have applied for the candidature. A written test of marks was conducted on 6th November 2022. It be noted that a maximum of 30 marks would be awarded for experience in the rank of ticket inspector starter, but this is the incorporation, deviating from the original parent notification. At the rate of 2 marks per completed year of experience in the above mentioned rank, and maximum of 10 marks should be awarded to those who have satisfactorily received satisfactory service record during last 5 years with no punishment awarded pursuant to the disciplinary proceedings or previous ban or promotion. Second, prospective candidates. Now comes the question of prospective candidates. How come you can include the prospective candidates? Candidates already appeared. They have been made eligible in the written test. Now you are saying prospective, meaning thereby you are trying to induct other persons who have not applied at all. The question of prospective does not arise. It is already, application has been made. Now number of application has been made as 87 aspirants. Prospective candidates shall have to secure minimum 27 marks out of 90 marks. It was initially 50 marks. Now it has been increased to 90 marks. As detailed above, aspirants who will qualify at this stage will have to appear for an interview for 10 marks. The question of interview does not arise. MCQ 40 marks, written ability test, whether you have the right, whether you have the ability to write down a particular thing, that is for 10 marks. Kindly see the parent memo. Last paragraph. Written marks of written test MCQ, multiple choice question, 40 marks. Report writing ability.
An interview will be held.
Yes, report writing ability 10 marks.
After written test, interview must be held.
Interview must be held. But that for that reason, for holding interview, there was no marks allotted. In the parent memo, there was no marks allotted. There was no marks allotted for the purpose of experience. That has been incorporated as 2 marks per completed year of experience, up to a maximum of 10 marks to be awarded for 5 years of no punishment being awarded. That is a first incorporation. Second incorporation is prospective candidates may apply.
Yes, got it. Don't
third is that
don't repeat. Thereafter they prepared a list.
Yes, they prepared a list incorporating 16 persons who have been made eligible as per the modified.
Your name has not been included.
No. And that is my challenge. And these 16 persons have been made a respondent number. These all has been incorporated and made respondent numbers. I tell you, Lordship, from respondent number 7 to 21. All 1 to 16 at page 23 has been made respondent as 7 to 21, and all has been served. The affidavit of service is in your Lordship's record. Now, pursuant to a RTI application, I got.
You got 8.20. 8.20.
Yes. Now, my lord may kindly see, and my name appears as against serial number 66 and serial number 58. What they have done, my lord may kindly see page 25 once. Page 25, top. Name of the applicant, employee number, date of promotion, reservation category, whether they belong to general, schedule caste, schedule tribe, marks obtained in the written test. Now, that after that, score in seniority. They cannot incorporate. Therefore, service record. These are the marks which has been allotted post
in seniority.
Post holding the written test, but prior to holding the interview.
Okay, what is your explanation?
Madam, what they stand they have taken in their report in the form of affidavit
Yes.
is a very surprising one. Kindly see paragraph 6 of the report in the form of
Yes.
Paragraph 6.
Yes.
The petitioner in the instant writ petition have alleged discriminatory treatment on the part of the respondent corporation causing prejudice to their right and interest. It has been further alleged that the authority departed from the declared principle of the selection process. Kindly see, they admit it. It is humbly submitted that taking a liberal view of the matter, the aspect of seniority was not clearly mentioned in the first circular and was supplemented by the second circular to extend justice to the senior and experienced members of the staff. The inclusion of 2 marks for seniority has been done to boost the morale of the workforce who have rendered long and meritorious service in the organization. The second circular was issued with a view to preserve the standard of promotion process and not motivated by bona fide or oblique motive. But they admit that it has been done. What they say, they only to boost the morality. So to boost the morality, they now change the entire rule of game. Now, to this matter, I will be citing one decision, very parent decision.
Yes.
Kindly
ask yes. What is the proposition? Tell. Unreported or deported?
Unreported decision. I am giving you a copy. I will handing over my copy to your lordship.
Single bench?
No, division bench.
What is the proposition?
Division bench presided over Justice Dipankar Datta.
What is the proposition?
May I read out? The same proposition. You cannot change the rule of game.
Cannot change the rule of game in the midway of the.
Yes. Although it is not for the court to redetermine the appropriate method of selection, page 4.
Oh, don't keep the court waiting.
Although it is not for the courts to determine the appropriate method of selection, we are inclined to the view that after issuance of the advertisement and immediately prior to conducting the process of selection, the board ought not to have taken a decision to assess the job aspirants on the basis of additional marks of 10 marks and working experience with the government 5 marks, in addition to the assessing their candidature on the basis of the academic qualification and allotting marks to each candidate out of 100 marks instead of 85 marks. Distribution of the marks in the manner decided by the board in the 96 meeting amounted to the change of rule of game after the game has started, which is impermissible, which having regard to the decision in K. Monjusri by the state of Andhra Pradesh, reported in 2008, volume 3, Supreme Court cases, page 512. In our opinion, board's jurisdiction, having been limited to the notification dated 1st August 2012, could not have acted beyond the boundaries set by the notification constituting it. In that view of the matter, allotment of the marks for additional experience of 10 marks and working experience with the government 5 marks in favor of the candidates who were appointed on the post of the inspector of drugs was absolutely illegal. The petitioners were not informed at any stage of the process that the board has decided to award marks for additional experience and working experience with the government, and therefore it is not a case where the petitioners had taken a chance of selection and having failed to get selected, turn around to challenge the process of the selection. We have therefore proceeded to assess the merits of the petitioners who are the candidates who have been appointed on the basis of the total marks of 85 instead of 100 marks. My lord, I am handing over. It is unreported decision. I have given a copy to my learned friend. Now, I will not be relying upon the other decisions, but there is a absolutely recent decision of the Honorable Apex Court. Paragraph 52 to 56. Porimal Kumar versus State of
Paragraph?
This judgment, paragraph 52 to 56.
52?
52 to 56.
56?
Yes.
Okay, tell me what is the proposition.
That judgment,
reading
the thick one I have handed over to lordship.
Entire judgment, tell me what is the
same proposition has been laid
Same
out.
proposition? The rule of game cannot be changed.
Yes.
Okay, same proposition.
May I just read out one paragraph?
Para 55.
Para 55.
Yes, I have got it.
The position of the law as
Okay, got it. Next, fine. What is your clarification? Sir?
My lord, the clarifications, my lord, I will be giving to all the points that has been raised by my learned friend, my lord. My lord, for my first submission in this regard is that, my lord, the petitioners being unsuccessful candidate in the selection process and having participated in the selection process first and thereby after being unsuccessful.
Okay, got it. Unsuccessful candidate, but after participating the selection process cannot challenge the same.
Yes, and this is exactly what has been done in the by the petitioners here.
Okay.
Now, my lord will kindly first come to the representations of the petitioner. My lord, at page 27. 27 and 28 is the representation of the petitioner. My lord, may I read? This is for your kind information that the notification dated 16 June 2022 was issued by the Joint Managing Director for awarding promotion to the post of TS from the post of inspector or starter, etc. And also other terms and conditions of promotions were clearly laid down therein, which provides that the rule of promotion is merit cum seniority. But subsequently, he issued a circular dated 6 January 2023 in connection with the notification dated 16 June 2022, which was issued after the completion of the written test. Even very recently, it was come to my knowledge that the above circular was issued in contravention of actual rule of promotion, which you filed in Honorable High Court in a case of promotion challenged by affected staff. So the entire process of promotion is bad in law and liable to be set aside and quashed. So I request you to kindly cancel the entire promotion, including the list of promotion dated such and such, and take steps for promotion as per law and oblige. My lord, the contention of the petitioner was at the beginning that yes, the promotion process has been initiated following the rule, that is merit cum seniority. There is a corrigendum which was issued later on, that is 6 January 2023, which is in connection with 16 January 2022, my lord, the parent notification, which was issued after the written test. And now after completing the examination, after going for the interview, after seeing the panel list, after writing to the authorities, obtaining the score sheet by the VDA and RTI application, now I have come to know that there is some matter in High Court where you have filed some report or something by which you have stated your promotional policy. So you challenge this. So you quash this, or you set aside the entire selection process. Now, my lord will come to the prayer portion of the writ petition. My lord, paragraph number 15, page 15, the first prayer.
Yes.
A writ and or in the nature of mandamus do issue commanding the respondents, particularly the respondent number 4, managing director, to expunge the seniority marks in score sheet and incorporated on the midway of process by setting aside the letter dated 6 January 2023 and thereby amend the promotion plan. Completely contrary to each other. Completely contrary to each other. Now, my lord will kindly comes to the panel list that has been my lord published at page number 23. And this is the panel that has been published, my lord.
Yes. I'm here.
My lord, there are 16 persons who have been awarded promotion by way of this panel, my lord. The petitioners are not a part of this panel. Why? That the answer is, my lord, at page number 25. At page number 25, my lord, the entire score sheet has been provided to the petitioner. That has also been annexed here. Now, my lord, the dispute, as has been alleged by my learned friend, is with regard to the seniority. That seniority was always there, right in the parent notification, and has been conducted, and the entire selection process has been conducted as per the parent notification only. There is no divergence from the parent notification. My lord, even if I do not consider the seniority, the marks awarded as for seniority, if that column goes, my lord, Even then the petitioners does not succeed. Hence the representation that you set aside the entire panel, you set aside the entire selection process. After which, my lord, they have applied. This is an afterthought. This is completely an afterthought that you expunge that seniority and you amend that panel and you incorporate me therein. Even if I do not consider, my lord will kindly comes to paragraph, page number 23, my lord. I have.
Yes.
Yes, my lord, I have made an endeavor, my lord, to, my lord, assess the persons incorporated here in the panel only on the basis of their interview and only on the basis of their marks that they have obtained in the written examination. Now, my lord, that is not with me. That is not with my lord, my lord. It is my own personal note, my lord. Even after adding up the 2 marks, only interview and written test marks, leaving aside the experience and the seniority marks, the petitioners still do not qualify. Hence, the writ petition fails herein. The petitioner is not entitled to receive any award. This is my first, my lord, arm of submission. My lord, the next is my lord will kindly comes to a timeline. My lord, 16th June 2022 is the parent notification. It is at page number 18. May I take, my lord, to page number 18? My lord, page number 18, it says, it has been decided to fill up 16 posts of traffic superintendent on the basis of merit cum seniority, right at the top. The first thing that the notification says is the rule of promotion which will be followed herein is merit cum seniority. The petitioners were always aware that the seniority would be taken into consideration. Page number 19, my lord, 17th October 2022, it is a notification only stating that the written test will be conducted on such and such date and the marks will be such and such. My lord, here also, it says that provisional admit card will be issued by from TSS's office Esplanade on and from 21st October 2022 without verification of eligibility criteria as mentioned in memo number such and such dated 16th 2022, which is the previous notification that I was reading, my lord. It will be verified at the next stages. If the applicant does not fulfill the conditions of eligibility, his candidature will be cancelled. Now, my lord, may I again take, my lord, to page number 18. My lord, page number 18, under the eligibility criteria, my lord will kindly see satisfactory service. There is a my lord, column which says satisfactory service. The intending employee should have a satisfactory record and no punishment awarded pursuant to a departmental proceeding leading to a lower post, no debarring of increments, no ban of promotion which is in force. This is one of the criteria. Further, my lord, if I take 2 paragraphs above, the first paragraph of this, my lord, if I may I read, my lord. It has been decided to fill up 16 posts of the traffic superintendent on the basis of merit cum seniority from the aspirant of staff members presently holding the rank not below the traffic inspector cum starter, who are in 5 years of satisfactory service in the post of eligibility criteria and reservation of post is stated therein. Now, my lord, I take my lord to page number 6th January 2023, which has been challenged by my learned friend, allegedly challenged by my learned friend. In terms of the notification in terms of the notification dated 16 June 2022, the parent notification for filling up 16 traffic superintendents, 87 aspirants have applied for candidature. A written test of 50 marks was conducted on 16th November 2022. My lord, I pause for a moment to state, my lord, the petitioners have participated herein in the written test. It is to be noted that a maximum of 30 marks would be awarded for experience in the rank of ticket inspector cum starter. senior rank at the rate of 2 marks per calculated year of experience in the above mentioned rank, and a maximum 10 marks would be awarded to those who have a satisfactory service during the last 5 years, and with no punishment awarded pursuant to the disciplinary proceeding or previous ban on promotion. The same language, the same thing which is there in the parent notification, which I just read. So there is no deviation first.
No deviation, how?
My lord, the first parent notification has, right in the beginning, has, my lord, informed that the entire selection process will be carried on merit cum seniority. So, my lord, if seniority is not considered, then, my lord, how will the process be conducted on the basis of merit cum seniority? It was very much in knowledge of the petitioners. The petitioners themselves have admitted that on the by terms of the notification dated 16 June 2022, they have appeared in the examination. They have they are fulfilling the eligibility criteria. They have appeared in the examination. They have appeared after the 6th January 2023 corrigendum that has been issued, stating that your seniority, 2 marks per seniority. Only by 6 January 2020, by 6 January 2023, only the marks distribution has been disclosed. How the seniority marks will be given to you. It is not that seniority has been incorporated by 6 January 2022. Seniority was there right from the very beginning, in the parent notification itself. It says merit cum seniority.
Okay, got it.
Yes. Now, my lord will kindly, and my lord, the next limb of submission is that the petitioners will even if I forgo the seniority marks, the petitioners are not succeeding. My lord, it is as per their own, as per the score sheet, which they have also obtained, which they will also agree to. Now, my lord will kindly cease. May I just hand over my sheet?
No, okay. So, I have got your point. Even if the marks awarded towards seniority is
done away with,
then also he will not be able to secure the job.
So it is a case of unsuccessful candidates after having applied, after sitting in the examination. And my lord, if this notification dated 6 January 2023, as per my learned friend submission, is incorporated midway, and if my learned friend is aggrieved by such notification, he should have challenged it or not participated in the selection process. He participated in the selection process. The interview was held later.
Same point.
Yes. My lord, thereafter, my lord, may I only, there have been two judgments that my learned friend have, my lord, relied upon, my lord. May I only contradict them?
Distinguish the judge.
Yes. Distinguish, my lord. My lord, the first judgment, my lord, that has been cited is WPST 120 of 2018, my lord, stating.
Yes.
WPST 124 of 2018. My lord, it has been stated, although it is not for the courts to redetermine the appropriate method of selection, we are inclined to the view that after issuance of the advertisement and immediately prior to the conducting of selection process, the board ought not to have taken a decision to assess the job aspirants on the basis of additional experience and working experience with the government, in addition to the
such they have prescribed that.
Yes, my lord. Now, my lord, here, my lord, my learned friend has cited this judgment. However, my lord will kindly considers that in this judgment, my lord, the petitioners had not participated in the selection process after they had detected there is a discrepancy with regard to the main notification. They have challenged that discrepancy. They have challenged the notification where the discrepancy arises, and hence it was interfered with. They were not unsuccessful. These people, my lord.
Got it. Your
Yes.
point.
Now, my lord, may I cite a judgment of my own?
Yes.
My lord.
Yes.
My lord.
Here's the proposition only.
2023 17 SCC 147.
Yes.
My lord, paragraphs number 9, 12A and 90. 9090 9, 12A and 19. My lord, paragraph Tajveer Singh Sodhi. My lord, may I read paragraph number 9? On 18th September 2009, the board published the select list and recommended 64 candidates for appointment as drug inspectors in Drug and Food Control Organization of Jammu and Kashmir. The select list comprised of 42 candidates selected from the open merit category, and a total of 22 categories were selected amongst the other reserved categories, out of which 14 names were selected under RBA category. The board on 15th October 2009 placed the select list before the Health and Education Department, being the department concerned, for issuance of the appointment orders after verifying the original documents. Now, my lord, will kindly comes to paragraph number 12A.
Yes, where is the proposition? Say, yeah, let down in this judgment.
My lord, the proposition is that if there is no malafide or arbitrariness, even if there is a rule game, even if there is a change in the rule of game, it ought to be allowed, seeking in consideration the welfare of the organization which is recruiting or promoting its employees.
Okay, take me to that proposition. Paragraph?
Paragraph number 90, my lord.
19. 19.
90.
90. 90, most probably it will last paragraph 65.
My lord, I'm really sorry. I have made one mistake. That is not that one. My lord, it is the same name but different judgment, my lord.
Okay, take it back.
My lord, this is 2023 SEC online, page 344. My lord, I have only one copy, my lord.
Yes, give it just
page 344.
show that proposition. Even if the selection committee can be allowed to change the rule of game in the midway, considering the interest of the establishment.
My lord, may I hand over?
Yes.
And my lord, that unsuccessful candidates cannot challenge after my lord, the panel has come out. Nine. 90. হ্যাঁ ওটা ঠিক ইয়েতেই আমি খালি একই নামে দুটো
Yes.
That's all? That is my submission.
The dispute involved in the petition has আবার আর কিছু চিন্তা পাচ্ছি হ্যাঁ 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 up to 2
From 2.
Now tomorrow, no, another, yeah, 8:15. Okay. No, not tomorrow. Change the